Any mention?
Please, Lordship, I beg to mention item number 25 to 28, the all connected matters. Conducting counsel is out of station.
What's the matter about?
Please, I was deregularized post-regularization.
Yes.
No objection.
No, Your Lordship.
After 2 weeks, my lord.
Top
Very
by Your
obliged.
Lordship.
Supplementary list item number 1.
Yes.
I beg to mention item number 17, my lord. Because the conducting counsel is some personal legal matter. Kindly examine the matter for the
No objection.
Okay, 2 weeks, yes.
I am obliged.
Well, item number 21. I'm for the respondent district council, my lord. My friend is for the petitioner.
I'm for the
Making a
petitioner.
joint request, my lord. Can this matter be taken after 2 weeks, my lord? Hello.
Item number 1.
My lord, here the petitioner, there was an order passed in page 74, annexure 3, my lord.
Yeah. Yeah.
If my lord may kindly see the second last paragraph, had the parties prima facie case exist against the respondents, the Director General of Police Meghalaya shall depute an officer not below the rank of Under Secretary to the government to investigate the case under section so and so and to submit a report on or before 15/1/2026. The police officer deputed by the Director General of Police shall collect the relevant documents from this office, copy of this order to the Director General of Police and all parties. Here, my lord, the petitioner is the VEC, my lord. There was an order which was passed by the Lokai itself that they have no jurisdiction over the VECC.
Public office, public officer.
Yes, my lord. Whether VEC falls under the public office or not. Now, they have passed an order for conducting a fresh inquiry against the VEC members, my lord. Now, my lord, there was already an order of the Lokayukt where they say that we have no jurisdiction.
Yes, no,
There can be
pending, correct?
Yeah, yes, my lord. There was two cases. So, my lord has already granted stay on that matter also. My lord, I will pray for the same order, my lord.
Similar case, my lord.
And we have pointed out, my lord, this we have pointed out to the Lokayukt. And a very,
Where you mentioned that earlier case?
my lord.
Order you have, no? This is the order.
This is the order, my lord, which was passed by my lord.
No, where's the earlier? Where you
That
mentioned
is the order, last order.
I've mentioned in paragraph 15, if my lord may kindly see.
There's no stay order here.
No, my lord, there was an order passed, my lord.
There was stay.
There was stay.
There was stay, my lord. There is a stay in
The one.
What number case?
It's not the one.
My lord,
Order is stay order is 23/7/2025.
23/7.
Yes, 23/7/2025, my lord.
This is 12/8. Okay. Heard Mr. Yes, the 11th counsel of the petitioner issue notice. Mr. N. Sincon, you're representing.
I'm representing the respondent, my lord. BDO.
Block developed officer.
Yes, ma'am.
I'll take steps for the others, my lord.
On behalf of the respondent number 10, steps to be taken for service on notice upon other remaining respondents. Other respondents within 3 days from Ms. SD Learned counsel for the petitioner submits that the grievance is directed against.
I have mentioned about the pending matter in para 17, my lord.
Grievance directed against an order dated 15/7/2025, whereby the respondent number 1
Yes.
has directed for investigation under section 20(5) of the Meghalaya Act and for submission of report by the designated officer. Stop. It is submitted that it is further submitted that the jurisdiction of the respondent number 1 to entertain complaints against Village Employment Councils is still in question in WPC number 298.
2025.
Where is the paragraph?
17, my lord. Page 17, paragraph 17, my lord.
That is problem. In WPC number 298 of 25, which is pending adjudication to this court. And councils have it is submitted that the impugned is clear, therefore, that in the interim that the impugned order be stayed and these two matters be tied together.
Yes,
for disposal. So, Mr. Edson Leonard counsel for number 10 has no objection. The court is stopped. Accordingly, in view of submissions, accordingly, it is directed that the impugned order dated 15/7/2025 shall remain suspended until further orders. Stop. This matter together with WPC number 298 and the next date. Stop.
Hello.
2,
2 to 3 are same from the same work order, my lord. Item number 2 to 2, 3, and 4, my lord. From the same work order, it has come up, my lord, where I have my security deposit has not been released by the power department. My lord.
Facts concluded.
So
You have concluded. Who's appearing for the respondent?
no, we have served the notice, but they have not accepted. So notice has to go, my lord. Our grievances is very limited, my lord. That application dated 23rd June 2025. That is on Annexure 5, page 27. We are making a representation to them to release our
Annexure
security
5?
deposit.
Page.
Page 27, Annexure 5, letter dated 23rd June 2025.
Yes.
We have requested them to release our security deposit because the work is already over and we have handed over. Amount is in one of the project is 43 lakhs 46,000. It's reflected in page 28.
Yes. Okay. Heard. Mr. SDN counsel the petitioner issue notice returnable in 1 week.
My lord, I will take steps, man.
Petitioner take steps for service of notice upon the respondent within 3 days. Stop.
Hello, listen.
List according answers.
Hello.
item number 5,
Lordship, may it please the Lordship. Lordship, this writ petition has been filed by 10 writ petitioners for the common cause of action.
Petitioners.
Lordship, for the common cause of
What is the
action.
prayer?
The prayer, Lordship, to rectify the date of redesignation to the rank of warrant officer.
What are the light? This says from the car windscreen. Look at Palang behind it. The reflection of the car windscreen is hitting my eye. Yes.
To rectify my date of redesignation to the rank of warrant officer. And Lordship, this matter is also covered.
Rectify the rate of the
Date of redesignation to the rank of warrant officer. And this matter is covered by the order of this Honorable Court, Lordship. And I have enclosed the order also, Lordship. That is
17 order.
Annexure 2, page 26. Operative part is at page 60, Lordship.
Justice TN casing order.
Same, Lordship. Only the trade are different,
Commodita
Lordship.
is
I'll have instance on file affidavit.
Paragraph 34, Lordship.
paragraph
34. Page 60. 30.
page.
Annexure 2, page 26. Operative part is at page 60, paragraph 34.
60.
Yes, Lordship. 60.
If you're not part of the contempt proceedings, no.
No, Lordship.
You sure about that?
Lordship,
They're cipher, my lord.
There's a cipher.
They're cipher.
I'm cipher.
Contempt is with regard to oral.
But cipher's already covered.
No, it has been given to them, my lord. They're coming after 13 years now to
No, Lordship.
Already covered. Cipher's already covered.
my lord. And he has been given, my lord. He is only asking for
Cipher
entity.
already covered. I mean, all. Yes.
No, Lordship. My date of
What's your prayer here?
to rectify the date of
Antedating
redesignation.
the redesignation.
By how many? What's the difference?
Lordship, the difference is, Lordship, I was supposed to be redesignated with effect from 10/10/1997, but since there are different petitioners, so I have included the date of redesignation at page 14, paragraph number 15. So on different days they were redesignated recently after the passing of the common judgment in order, Lordship. So there is no delay also, Lordship.
Yes, but Mr. B. Dev confirmation notice returnable in 3 weeks. Dr. N. Mozika, Media GI, so present, except on behalf of all the respondents, no document is required. Just after 3 weeks for my instructions activate.
Item number 6.
What is this?
Please, Your Lordship. Lordship, the petitioners and 14 other families are before this honorable court, my lord, as they have been denied justice, my lord. They have been ostracized from their family, ostracized from the village, my lord. If Lordship recalls, there was one matter pending before this honorable court, my lord, WPC 25 of 2025, my lord, that Sangma case. Samsara case, same, of the same village, my lord.
Same petitioners.
No, they are different petitioners, my lord. Herein what has happened, these people and 14 other families, they did not participate in the vandalism, my lord, of that Sangma's house and the other petitioner, my lord. Thereafter, the other villages, my lord, headed by this greater son, who is also a respondent there, my lord. Now, what has happened, they started targeting these families, my lord. Thereafter, they filed a complaint before the...
What did the police do?
They didn't do anything, my lord. In fact, they are actually supporting the respondents, private respondents here in my lord. And what they did, if Lordship comes late at night, they sent 2 police personnel, my lord, at the widow's house, who was also ostracized, and they asked for the signature, my lord.
What signature?
In a blank paper. They did not consent to that. Thereafter, the 2 police personnel left, my lord. And the police, they are constantly coming and asking them to withdraw the FIR, my lord. No action has been taken till date against that FIR. And complaint was filed to the SP also, my lord. FIR, my lord, if Lordship comes to Annexure 1, page 17. This is the FIR lodged by the wives, my lord. And the translated copy is at page 19.
This is not Garhills.
This is not Garhills, my lord. This is connected to that same matter, my lord.
What's the stage of the other matter?
The other matter, actually, I'm not aware, my lord, what has happened there.
You're the petitioner there?
Yes,
the
my
wife of the petitioner there?
There, no.
Who's the lawyer there?
I'm not aware, my lord.
25, who's the lawyer for the petitioner?
Oh, WPC, I'm the lawyer.
Counsel
I'm
for
the counsel for the
What stage is the case? Is still pending?
It's still pending here, my lord.
At what stage is it? For hearing or still?
For hearing, my lord.
Is fixed for hearing?
It's fixed for hearing, my lord.
Lordship, on the last date, my lord, at WPC number 25 of 2025, the counsel for the private respondents has submitted before this honourable court that the matter has been charge sheeted, lordship. That's on record, lordship.
In one of the FIR, it has not
Who was
been.
the lawyer appearing for
Mr. K.C. Gautam.
K.C.
lordship.
Gautam was appearing, my lord.
Okay. Now your allegations are that
The respondents, my lord, the villagers, they're still ostracizing the other villages, so I mean other families, my lord, of that same village, who did not participate in the vandalism, my lord, which took place.
so they want them to participate in the vandalism also.
Yes, but they did not. So thereafter, what has happened now? They are not allowed to use the field. If the children go and play in the field, they started assaulting them, my lord. And they complain it before the police station also. No action has been taken so far.
Yes.
And now they are more emboldened, my lord, because the matter was pending before this honourable court.
Lordship, with regard to the other petition, it's been charge sheeted, lordship. Serious allegations have been raised.
This is not Garo Hill.
So, lordship, and many.
They say that it has been
Private
charged sheeted, my lord, but it has
respondents,
not been confirmed till date, my lord.
That's unfortunate, lordship. It's fallen from the counsel for the private respondent, lordship.
Let the OC whatever appear in court.
Lordship, let me seek instructions first, my lord.
If the first petition, okay, fine, whatever happened, but then if the repetitive action of these people, that means that they have not been. What do you mean? They have not been warned, or they have not. They are emboldened by inaction of the state respondents.
Lordship, I cannot make any comments offhand, my lord, but kindly allow me to seek instructions, lordship.
Otherwise,
Lordship can have it after a few days, my lord. I'll seek instructions accordingly.
yes. And evidence, if it has been filed, has a case been registered, you have no idea.
No, it has not been registered till date, my lord.
It's on record, lordship, on WPC number 25.
See, taken pictures of those two policemen also making.
Lordship, I'll have to seek instructions, my lord. It can be anybody's picture also.
This, it can't be somebody's picture.
Lordship, yes. So I'll have to seek instructions, lordship.
Yes, take down heard Ms. A.G. Movement and the Council of Petitioner. Issued notice, Mr. M.S. N.G. Shalala, Senior Government Advocate, is present with so-and-so except on the behalf of Response 124.
124, lordship.
Notice to could remain respondents within 3 days. Stop. Mr. A.G. Movement letter, Counsel for the Petitioner has submitted that this is the second round of litigation involving the same series of incidents in village. What's the name of the village?
Wakaugatam, my lord. Wakaugatam.
Village. Where can we get it? The name?
Huh?
It's at a synopsis, lordship, second line.
Village is Wakaugatam.
Wakaugatam, my lord.
Not Garo Hills, where it has been alleged that the petitioners and other residents have been victimized and ostracized by the villagers for the non-participation in for the incidents that have occurred in the said village. Stop. It is further submitted that in the earlier petition, the same respondents.
Only one respondent is same, my lord. There's greater son. Respond number 5. Whereas the others are
new actors.
New.
Yes, they submitted that the respondent number 5 is also a party respondent earlier petition. So, it is 5, and in spite of the logic of an FIR
5 and 6.
5
and 6 are the same respondents, my lord, in the earlier petition.
Filed on, in spite of logic of FIR on when do you file FIR?
6 July, lordship.
6 July, my lord. 6 July.
6/7/2025. There has been no action forthcoming from the police, and from the police top. We therefore praise that appropriate orders be passed. Like by MS N.G. Shalala, the senior advocate, prays that he may be allowed to obtain urgent instructions with regard to the allegations that have been made and whether the FIR has been registered, whether a case has been registered on the FIR has been filed. Stop. Only this is matter after 1 week.
Lordship.
Much obliged, Lordship.
Highly obliged, my lord.
1 week, 1 week, 1 week.
Item 7.
This matter was listed yesterday, Lordship.
Yes, Your Lordship. I highly apologize as I was unwell, so I had to rush to the clinic. May it please, Your Lordship. Lordship, after proper scrutiny of the writ petition, it is found that there are certain typographical errors which throw the case into a new light. So my prayer is that I may be allowed to withdraw the instant writ petition with liberty to file afresh, so as to enable me to rectify the errors.
In the petitioner submits that after filing the instant petition, certain defects have been noted which need correction. He prays allowed to withdraw the same with liberty to file afresh. The same like objected to by the counsel for respondents. The matter stands closed on withdrawal with liberty granted as claimed.
Much obliged, Lordship.
Item number 8.
Lord, I have filed my objection, Lordship.
Yes.
And now, my Lord,
What objection?
earlier, my Lord, the respondent state brought a new award statement, and Lordship allowed me to file my objection in the form of affidavit I have filed, my Lord. Before the two petitions are here, one from Iskar Seals and another is from Ripoy. My Lord, till date we are addressing the Iskar Seals matter. I would try to conclude it to the Lordship permission.
But the thing is that, Mr. Changreso,
Yes.
it involves only Ripoy or East Kasias?
My Lord, two districts are involved.
With regard to the
Two districts are
entire
in dire
assessment,
straits.
assessment, one assessment.
Different assessments. Different
You mean
assessment.
to say that the deputy commissioner's assessment at the initial point of time,
Yes.
there are two assessments made
Two
for
assessment.
two districts, and those were changed later on by
Yes,
the.
both of them changing.
But are they identical? The entire
But the
depth, I mean,
35 kilometers is under the same land acquisition process, they do. But Section 1119 declaration for East Kazil is different from Ripoy district. Even assessment
The
also.
whole issue is that assessment was made.
Yes,
And a certain amount was arrived at by the deputy
Yes.
commissioner, correct?
yes,
Then there was some between that time and there was some correspondence or some consultations that the amount was high on the
Yes.
higher side.
Right.
And so a new amount was fixed, correct?
right, right.
That is a core issue.
That is the core issue. With my contention, therefore, whether that amounts to review of the award or not.
No, whether
that is the only
it's
issue.
not that review is whether the award that was initially arrived at, whether it's the final award or not.
Yes, my lord.
If that's a final award, then,
Yes.
then maybe whether they have,
Yes.
the jurisdiction or the power to review the same.
Right, right.
If it's just a draft award, then you don't have a case.
Yes, yes, my lord, my lord. If it is a draft award, there is a contention of the
Draft award,
state.
you don't have a case.
I don't have a case. Another remedy is available. But if it is a final award, then the second award, so-called, is amounts to reviewing of the order.
What's the difference between the first and the second?
My lord,
The amount?
my lord. Therefore, the contention is, my lord, I said the first one is a final award. The state said it is not a final award. Now the true will be available from the record itself. And the land acquisition lordship is aware, collector and the state is the author of the land acquisition process. The land losers has no right to interfere with the acquisition process. Whenever they give time for objections or participate in the hearing, the loser will come. But the entire acquisition papers are authored by the collector and the state. Now my humble contention is, therefore, the record itself would demonstrate. My lord, before I would go to the objection I filed, my lord, a short glimpse of the few papers in the main petition, so that my lord would appreciate better the.
How long will you take?
My lord, I would take my lordship permission. It take some time. We want to conclude from my side. I want to conclude the matter.
Then we'll take up the other
Yes.
matters first.
My lord, my lord.
Item 15.
We have filed remove the application under section 340 of CRPC law because
One second. You have to submit list. Huh? Yes.
We have moved the application under section 379 of BNSS for making a false statement of vote regarding the memorandum of that minutes of meeting, regarding minutes of meeting held between the parties. We have filed because the representative of the petitioner participated online. We have got the documentary proof. We have circulated and gave it to the Lordship. My application.
May please, Your Lordship. May please, Lordship. Lordship, there were some defects in the application. May I?
What application?
Lordship, the application. BNSS, Lordship.
It's not common record.
Lordship, there was some defect.
Along with my application.
Tomorrow this course is not there. So we'll take it on Monday.
Yes,
Submits that an application under section 379 of the BNSS has been filed alleging perjury.
Perjury, Lordship. I'm not sure whether. It's fine. Let them give me a copy.
Let the matter appear on Monday.
Lordship, that interim order, the Lordship, they kindly be extended.
The person is not maintaining the entire site at all. The lists are not working.
That is on merit.
DG set was not working. Now they have only because they have filed a petition. They are enjoying some mistake. And they are lying on this.
So fine, Monday come prepared, we'll finish it off.
Lordship.
No issues.
That will be extended. Lordship.
Yes, you have to take up entire matter.
Absolutely.
Yes,
Obliged, Lord.
Is the other connected matters or the main petition together on Monday. Yes, interim order of any shall continue till Monday.
Lordship.
Daily list item number 1.
Wait, please, Your Lordship. Lordship, in this matter, I'm praying for some time, Your Lordship. It's fixed for evidence, Your Lordship.
We won't give any time.
Lordship?
We'll reject the application. What are you going to do? Because your witnesses are from here only, correct?
Yes, Your Lordship.
Then?
We have some personal difficulties, Your Lordship.
What personal difficulty?
Medical emergency, Your Lordship.
Of Mr. Pandey?
Yes, Your Lordship.
And another thing is that you not even prepare the summons. I'm informed with the office.
Lordship, we'll give it today, Your Lordship.
See, if they are your witness which you want to present them for the court, then the counsel for the respondent of a petitioner has to prepare the summons. You file it in the registry, from where they'll be issued, be received by the witness, then the witness will come.
Lordship.
When do you want it?
After 3 weeks, Your Lordship, we'll fix the date accordingly.
Yes, seen application for adjournment so and so. For the reasons stated, this matters 3 weeks, yes.
Obliged, Your Lordship.
Prepare a summons well before the date of examination witnesses.
Lordship.
When you get the date and before that, you prepare the summons, yes.
Item number 2.
Please, Your Lordship. I am appearing on behalf of Mr. R. Gurung. He's on his legs. Mr. R. Gurung, Your Lordship. So I may be allowed 3 weeks time to file the affidavit in opposition, Your Lordship.
1 second.
Petitioner Mr.
Bora,
he's not.
He treats this being a lawyer as casual employment, I think.
2 and 3 connect.
He doesn't appear. It's like sporadic appearance. Only interest of justice thinking about the clients that
yes,
what's allowing time, yes.
2 and 3, Your Lordship. Both the cases are
yes,
much obliged, Your Lordship.
For 2 weeks as prayed allowed for respond to file affidavit stop. It's noted that today also there is no appearance on behalf of the petitioner.
Item number 4.
As per the last order, the respondent one supposed to take.
Yes, who's one of one?
Mr. ASD, Lordship. He was here.
Yes, MS Alcolni. Who's appearing for 101?
Mr. ASD, Lordship.
What instructions have been received?
My lord, kindly have this matter at the end of the board, my lord.
And why?
Because Mr. Day is here, my lord. Probably he must be in the other court.
After some time.
Item number 5.
Late pleasure. Item 5, my lord, matter is still pending with Department of Finance, my lord. So, Lordship, you have it after 10 days.
How longer will it take? Are the people being deprived? Are the people being deprived of medical supplies?
No, the alternative arrangements have been made, my lord.
Otherwise,
certain items in the city won't be, my lord. So therefore,
you see, Mr. Advocate General, you have to look at the bigger picture. If the whole, the medical supply of to all his PHCs is affected, I mean, one people are affected.
Lordship, that is one aspect. The other aspect is that, Lordship, this is a single bill. So, Lordship, as per the finance department's their own notification, Lordship, it has to be generated, Lordship.
Will you take a call? We will have it after 1 week exactly.
Lordship.
Yes. Yes, Mr. Then Advocate submits that the finance department is still to pass final orders in the matter. Stop. It is noted that the matter concerns the supply of medicines to the supply medicines to the health department, which is to be used for the public. Stop. As such, there should be no further delay. This is a matter of the 1 week positively.
Lordship.
Item number 6.
Number 6.
May I please, Lordship? Lordship, all the respondents have filed their affidavits, Lordship.
All of them are filed?
Yes,
very good. Ms. Abraham also is filed?
Affidavit. Yes,
You have for 4 and 5?
Yes, 4 and 5.
6 is? What are you going to do now?
Lordship, rejoinder is not required, Lordship. Therefore, Lordship may fix for hearing, Lordship.
Ready for hearing today?
Yes, no, Lordship. Next time, Lordship.
Or next time? Yes. Sarah submits that the urgent will file accordingly. Raise the materials for hearing.
7.
Listen, so.
Lordship, in this matter, state is supposed to furnish me inquiry report, Lordship. However, till that...
supposed to file rejoinder also, my lord, as per the last order.
My lord, may I please, my lord? Item 9, 10, 11 and 12, my lord. I'm the petitioner, my lord. The 11 and 12 matter, they have not filed the till date, my lord. They have filed the affidavit, but inquiry report is not given, my lord. Why inquiry report is necessary, my lord? In the other 2 cases, my lord, inquiry is in my favor, my lord. But they have not.
11
and 12.
No, in the other 2 matters, the 8, 9 and 10, the inquiry reports are in my favor.
In all matters we have not furnished.
But we don't know yet, my lord. That is the entire
How do you know it's in your favor then?
Well, no, in other 2 matters, inquiry report, because first round of litigation, my lord, can you remember, I come before your lordship to protect my right.
I still can't understand. 11, 12 is in your favor.
My lord, 9 and 10, my lord.
But you have not got inquiry report.
I have received, and then the inquiry reports are in my favor. But 11 and 12, the inquiry report has not furnished yet, my lord.
Okay.
Because 9 and 10, I come before your lordship.
Yes, and Mr. M.R. Amara?
Yes, Lordship. As per last order, Lordship, state is supposed to furnish me inquiry report, Lordship, for item number 7 and 8, Lordship. Yes.
7 and 8?
Yes, Lordship.
Yes, my lord.
What about necessary affidavits?
My lord, affidavit in opposition has been filed, and lordship, so far as the inquiry, last time, my lord, on the last occasion, lordship they have prayed for rejoinder, to which lordship has also noted that they can bring that in the rejoinder affidavit also, that due to the non-furnish of the inquiry report, that can be also made part of the rejoinder. So, my lord, they have not filed a rejoinder till date.
Rejoinder is not necessary in my case, my lord. I'm not going to file rejoinder.
not necessary in your case.
No, my lord. But for his
If
case,
that is so, my lord,
Unless rejoinder, Lordship, unless inquiry report is punished to me, I will not be able to file rejoinder, Lordship.
Okay, in these matters 7 to 12, Lawyer Advocate General submits that in the cases where in the inquiry reports with regard to re-verification of job card holders.
my lord, this is a PDS matter.
PDS matter.
Oh, sorry.
My lord will remember, my lord, during the pendency of the case.
Sorry,
cancelled, my
Mr.
lord.
Hassan, I think it's BC or something.
No, my lord. My lord, not always VC, my lord.
Probably in these connected matters, Lawyer Advocate General has submitted that in the case of inquiry report have been furnished, the same be furnished within a period of 1 week. So, according list matters after 1 week for further orders.
My
Yeah.
lord. Hello, my lord.
Sorry, Mr. Hassan, really.
My lord, my applause.
13,
Please, Your Lordship. I'm praying for some more time in this matter, Lordship.
Where's the petitioner? You're not going to give NOC for resignation for retirement, correct?
Lordship?
You won't give the NOC for retirement. Yes, none appears of the petitioner as prayed for a 3 weeks time allowed for affidavit.
Highly obliged, Lordship.
14,
Yes, my lord. As per the last order, my lord, I still await for the counter affidavit that they have to file. I have
not filed. The tournament is over. Mauka Singh has won the tournament, my lord. Now it's become a fait accompli, my lord.
Then
Still want affidavit, we can file that, my lord.
Yes?
If they still want affidavit, we can file that, my lord. We can fait accompli.
this is the football matter. This is a football matter, my lord.
Yes?
This is a football matter.
Yeah, but it's over now.
So then, my lord, then allow me to implead necessary parties in this matter.
Necessary parties for what?
Because, my lord, they were supposed to be part of the disciplinary action. They were not there. These are the government officials, my lord.
Tournament is over, my lord.
Who have
We'll
funded?
do one thing.
Yes, my lord.
Cannot be turned back.
We close the petition, allow you to take alternate measures. You file a proper complaint. Since your urgent complaint that you had that time
Yes,
was that you disqualified, 3 points were deducted from you. You should have gone to record of finals, correct?
Yes, my lord.
Yeah, but then they had given the reason that the complaint, as per the rules, had been filed immediately
Yes, my
when the
lord.
match got over. But your complaint
Was not entertained.
was not there. That's the only thing. I mean, it was not filed. It was filed after 1 day.
Yes, my lord.
So that's the thing.
No, but
What
I
remains now?
filed my
The main-
complaint in time, but they
Let
did
us
not
see
hear
your
me.
prayer.
Yes.
If your prayer can sustain further adjudication,
My
then
only
yes. If not, then we'll close it.
Then
We'll
my
give
lord-
you liberty to.
it is at page number 11, 12.
Yes.
To re-examine the-
See. And it's pretty. We issue rule. Directing response to re-examine protests made with petition according to the rules to grant the other release. Directed to immediate meeting. So they have done that.
Then my lord, in this instant, can I please seek instructions for
Seek
just one
instructions,
week's time?
Yes,
What is the wish of the petitioner?
Observation of the court that the writ petition may be closed as the prayer made therein has since been addressed by the respondents. MS Bang prays without to obtain this up to 1 week instruction. You close it otherwise.
Yes, my lord, let me get instructions, proper instructions.
second call, item number 4,
Have you received rules of the petitioner? Have you received instructions from the police?
Yes, my lord.
He's been located.
My lord, if I may just submit this verification. There was an entire verification process that was undertaken with the Gram Panchayat and the municipality. Apparently, there are two addresses. One's a permanent address and one's a current address. If I may refer your lordship to page 2 and the underlined section.
Yeah.
Santosh such and such, age such and such, resident of 227 Rajputana, Gola village, police station. I think, Lordship, what happened in this matter was that my learned friend had the addresses combined, amalgamated. So these are the two addresses.
Is it still reporting to the police station?
Lordship, I'll have to take instructions on that. But
He's on bail, correct?
he is on bail, Lordship, yes.
He takes steps.
Lordship, if this is the correct address, I'll take steps on this address.
Mr. ESD today has produced communication dated 14/8/2025, wherein the correct address for respondent number 2, right? 2 has been furnished. Accordingly, the same taken on board, made part of the record. Council pressure to take steps on the address as furnished. List after
2 weeks, Lordship.
2 weeks, yes.
Grateful, Lordship.
Item number 8.
My Lord, whether the contention advanced by the state relying on the second award is correct or not would be, my Lord, easy to appreciate if my Lord again turn to few annexures in the main petition.
Annexure.
My Lord. My Lord, we come to Annexure 7, page number 52. Annexure 7, my Lord. After section 6, section 11 and 19 declaration. This is the section 21, 22. Notice.
This is 474.
Yes. So this is a notice issued to the writ petitioners.
This is dated 27 December.
Right.
Yes.
15 December.
Huh?
My Lord.
Annexure
7 is 15 December. Some are 16 December.
Sorry, no. Mistake. Annexure 7. This acquisition has given rise to a lot of litigation. Yes, no, but yes.
My Lord, we turn page 54. The inquiry was held on.
This Annexure 7, sorry.
Yes, after 57, I just want to show that this is a notice. Pursuant to this, inquiry was held under section 21 on 21st December 2022, page number 54, where some of the petitioners also appear before the authorities. On that day, my Lord, the
54 is a list of names.
Yeah, the minutes, attendance sheets on which date the inquiry was held. On that day, my Lord, the collector disclosed the prevailing market rates, and they satisfied with that.
Who's satisfied?
My Lord, the landowners appear, and they were shown the prevailing market rates. Therefore, they were satisfied. They appear.
Was it a public hearing or a meeting?
It is an inquiry under section 22. It was an inquiry.
Yes.
And thereafter, my Lord.
Where do you show? It's just a list of named signatures. Where do you see all these parties?
Yeah, they appear. They appear. Petitioners appear.
Where
several attendants are there, signatures are there.
These are all people over here.
But a total 178 people were attended.
178 people.
But landowners.
Okay.
And my Lord may take note, for East Khasi Hills, there are 196 landowners.
This is for Iboy.
This is for East Khasi Hills.
There are how many landowners altogether?
196.
Okay.
And out of 196, 130 of them are before my Lords.
And 178 attended the meeting?
Yes.
Okay, 178 attended the meeting.
Yes.
196 landowners.
Yes.
And the 130 petitioners.
Petitioners are here.
Okay.
Only 38 of them did not come before my Lords.
Okay. 48 then come.
Yes.
Yes.
And my lord, we turn to page number 72. Here the market rate was again clarified by the PTO to the collector. Page number 72, Annexure 9, 31st March. And it says, with reference to the subject cited above, I have to honor to inform you that the land valuation village under such submitted earlier, madam. So he has submitted before inquiry and has been clarified as under. So different categories of land valuation have been disclosed.
Where is it earlier? It's just a land valuation certificate, 31st March 2023, correct?
Yes.
Then it says that reference subject said above.
I have to honor to
the
inform
land valuation village of Soyong
yes.
Submit earlier.
Submit earlier. Because under before section 21 inquiry was held, he had submitted to collector. On that day, therefore, they showed these are approximately pro paper land valuation. So the landowner was satisfied. So this is sort some clarification.
Very happy with this rate.
Madam. So the collector sought some clarification. So he has given this letter again. Thereafter, my lord, the collector passed the award. Madam.
Is the doctor's video? Is a veterinary doctor?
I'm not sure, my lord.
Yes.
Thereafter, my lord, page number 76, Annexure 10, collector has passed his award. And this is very vital to revisit again with Lord's permission. Sin letter says as of 25th April 2022.
Your whole case rests on this, right?
Rests on this. Therefore, the content of this is very important, my lord. Sin letter received from 25th April 2022 received from the NHITCL with a request to submit the final award, my lord, kindly mark it, final award under section 23 after approval from the state government rather than submission of probable estimates. So the NHITCL say that give me the final award, not the probable estimates. With approval of the government.
You will request submit the final award.
Yes.
After approval.
After approval.
Then
after approval. Now the second contain hearing under such and such on 21st December 2022 as so and such in the presence of the landowners, head of the villages and representative of the NHITCL, and the landowners were satisfied with the land rate for payment of compensation. Therefore, as I said, my lord, on the day of the inquiry, the authorities closed that these are the probable market rates. So they were satisfied. Prepare the draft award, my lord. Accordingly, adding the mandatory solution 100 at the rate of 100% under section 31 of the Act, along with the 12% interest from the data premium notification under section.
Okay, now you stop there. What is the status of draft award then? Because the last paragraph says prepare the draft award.
Yes, my lord.
Does it mean that prepare a draft award according to the land compensation, the assessment arrived after the meeting? That is your case. That means, because we have to be clear also.
Yes.
There's something which I have no knowledge also. Suppose a draft award is made.
Yes. After
hearing, what is the power of? It's not a final award. What is the power of the state government to alter that award? It will be on what circumstances?
Yes.
That is what we have to examine.
My lord. Now the collector used the word draft, but relying on the rules of the state government rules 2017. Though the parent Act section 23 of the Act 2013, it doesn't require approval. Earlier all Act.
So whatever the collector fixes, it becomes the final award.
It is final, as per section 23. I would show, my lord. I would show. Section 23, in the earlier Land Acquisition Act, my lord, the award prepare, and until unless the collector approve it, the state government approve it, it is only a draft in nature. Draft in nature. Now, section 23, my lord, may kindly see the new Act. It says, on the day so fixed or on any other date to which the inquiry has been adjourned, the collector shall proceed to inquire into the objection, if any, which any person interested has stated pursuant to a notice given under section 21, to the measurement made under section 20, and into the value of the land at the date of the publication of the notification, and also into the respective interests of persons claiming the compensation and rehabilitation and resettlement shall make an award under his hand of true content of the award would be, my lord, true area of the land, compensation determined under section 21, my lord, and apportionment. Here, my lord, the approval from the government is not required. In my humble, therefore, contention is that, my lord, on the day he passed an order on 4th May, that is the final award. But collector has used the word or draft, relying upon the rules framed by the government. Now, to that aspect, may I just submit the compilation of the rules. My lord may come to central rules and state rules I have prepared. For the time being, I'll come to state rules only. My lord may come to page number 21 of that compilation. But this is a draft notification issued by the government to finalize the rules. Now, may I take the next page, my lord? Page 22, on the top is the draft rules. It says Meghalaya right to fair compensation.
But the Gazette, it has been.
Gazette is there, my lord. In the Gazette, but before I come to the Gazette, my lord, one page is missing. But in the draft one, complete page is there. Therefore, I take the lordship.
What do you mean one page is missing?
My lord, in the Gazette notification, my lord, the one page of the form is missing. It is not available in the website also. But in the draft here, it is available. Therefore, I export.
Okay, let's see what
my lord.
Page.
Now, may I come to, my lord, in that, my lord, we come to page number 31. Rule 14, it says. Rule 14, my lord, may I see. The collector shall make land acquisition award under section 23 of the Act as per Form 9 after obtaining approval of the government. So because of this, collector said my award is draft because government needed to approve. So the parent act do not require approval. And now the form is available, page number, my lord, may come to page 59 of that very compilation. Page 59 of the same compilation. Form 9, award statement, under Rule 14.1. So the word award statement is not provided under the Parent Act, but it is provided under the rules framed by the government. And this is draft one, and they have gazetted this one. My lord may come to page number 63. Is the gazetted rules, gazette rules.
So that Rule 14 is not in the Gazette notification?
It is there, my lord. Page number 60.
Which is the page missing? That missing page has relevance.
My lord, the missing page number 59. That page is missing in the Gazette. I'll show, my lord.
Okay.
I'll show. And my lord may come to...
1 second.
Yes.
Yes.
My lord. My lord, come to page number 63. The state has notified it.
Yes.
And I would come the same rules, page number 70, my lord. Declaration of award and compensation.
You mean to say, was it left out, or was it doesn't exist at all, or is not part of the paginations? All right, of the
pagination we have given, my lord.
No. As per the what this court is trying to say is this. Now you say that when the draft was made, this Form 9, correct? Yes. Which appears at page 59 of your compilation. Does not appear in the final Gazette notification.
Yes.
Correct. Now was it left out deliberately, or whether the draft
it is
didn't consider necessary to include it in the final notification?
by bona fide mistakes, my lord. When the government notifying the rules for public information.
Okay.
My lord, we turn to page number 70. 70 is in the Gazette.
Yes.
Same rule 14 is there. And it talks about Form 9.
Yes.
And Form 9 of this Gazette is available. My lord, can you see page number 91?
Yes, it's
91 is a part of the Form 9, but first part is missing.
Okay.
Just for, it's a bona fide mistake by the state.
Okay.
While notifying the public. But under the draft rules, it is complete.
Only that part?
Yes, only that part. Now I want to show here, therefore collector...
mischief in...
No.
Then?
Therefore the collector uses the word draft on Form May because he is going to take approval from the government.
So your argument is that Section 23 does not envisage approval, not envisage, not contemplate approval from the government.
Yes.
Once he makes the award, assessments done, 21, 22 meetings are held, then under this Section 23, that award is made, there's no question of any revision.
Yes.
It's final.
Right. And my
approval is not necessary.
Yes. Page number 76 of the petition, which we are reading the award paper, it says, my lord, they prepare the draft award accordingly, adding the mandatory solution. Now, my lord, until unless collector pass the final award, addition of 100% solution doesn't arise. Even 12% of compensation doesn't arise. Once collector made the final award, then the solution comes into the picture. Therefore, my contention is that the award he passed here is the final award. Though the collector sought for the approval. Now, my lord, we kindly see page number 76 in the petition, therefore. 78. Award has been prepared, award statement is under the Form 9 of the rules. And I would...
the award statement.
Award statement. Well, the award statement is not the language of the parliament, but it is the language of the executive while framing the rules. Well, one kindly see the serial number 4, page number 79.
Yes.
Situation here in extent of the land to be acquired with the number of plots in the survey map, the number of miles, kilometers, if any. Now, no can to Tompoy left hand rights and right hand rights, total area of this and such, total area of compensation, my lord. Here they have categorized 7 types of land carrying different land valuation. This is missing in the second award filed by the collector now. Therefore, I would come to that point. How the the collector...
No, what are you trying to say?
My lord.
Left and right, what are you saying?
Left hand side and right hand side.
LHS or LHS?
Yes, total area is this one. My lord, number 1, 7961 square meter. The rate of the market rate would be 600. Second category is 14224, 380 square meter. Third category is 392762, 3500. So 7 categories, different types of categories of land are there. And therefore here write the market value 28166, 34983. So this is a market value. Now when we see the second award filed by the collector now, it's not there. It is not there. Now, my lord, we come therefore the next page, 80, page number 80. Therefore, collector has consciously mentioned this. Serial number 14. Additional compensation interest under section 33 of the Act.
Now, also the basis of the meeting. It's a base of calculation, rate of compensation, fixed valuation by a BDO. But your case is that the meeting which was held under section 21, right?
Yes.
Inquiry under section 22.
Yes.
That the villagers were happy with the rate, same rate fixed with BDO.
Okay. Because the collector and the officers of the collector were there. So they disclosed that they were satisfied, more or less. So therefore, in his award order, which he passed subsequently on 4th May, he said the landowners were satisfied with the land rates. And thereafter, my lord, he prepared the award statement and forwarded. And when para 14, the point 14 of that page number 780, he made it very clear that the date of the prelim notification and the date of the award they mentioned, and the date of the declaration of the award is 4th May 2005.
Yes, sorry. Yes.
But therefore, thereafter, my lord, I would show page number 97. Earlier, my lord, the learned AG tried to justify that the date mentioned in the award notices is a bona fide mistake. It is not, my lord. Page number 95, annexure 97, annexure 18. Now the collector has mentioned in which you have treated as a interested person, an award was made on 4th May 2023. Madam Vaisi, page number 97. Award was made on 4th May. Page number 97.
Yes.
Therefore, in the award statement also they have mentioned 4th May. Award notice is given to 196 people, landowners. They mentioned this award.
What relevance does this have? Just the notice.
In the notice they mentioned the award because in this additional affidavit, collector has brought the subsequent award date, award statement. Award statement.
No, see, the thing is that now this amount 40 lakhs.
Yes.
Or 40 crores, sorry.
40 crores.
Yes. You got this amount.
That is it.
You accepted it.
My lord, this one was accepted.
Then?
But on the day they issued, they served this one.
You took it under protest.
But on the day they issued this, they received the notice and appeared before the authority here, submitted the documents. On that, the collector did not release the amount. They collected documents and they released this subsequently in their respective accounts. Subsequently. So on the day they appear, they informed the officer collecting the officer from the collector that the amount fixed by you mentioned in the award notices is different from the discussion we made during inquiry under section 21 video. They say therefore that it is the process is going on, and after the process is completed, appropriate award would be given. So they submitted the documents. They go back on that. None of them received the award. My lord, let me complete. I will not interfere with the AG.
Only one thing, Mr. what weight can you attach to this notice? Because dates given may be pre-prepared by the office only. So whether this date indication the date here will have any bearing at all.
But I might just
quote these are notices when issued a cyclostyle notices, the mistake, but it is not what do you call it, affirmative, or that it is that this amount has been fixed is as per the award dated 4th May.
It is a statutory notice. It is statutory notice. Therefore, they mentioned the award date. There is important is there. But even if for the time being, assuming that we can leave it aside, but the award order passed by the collector himself clearly mentioned in the award statement, the date of the award is clearly mentioned. Now I would come to the affidavit filed by the collector. Now in the first affidavit filed by the collector, she did not dispute all the passing of the award on
on the first affidavit.
In the first affidavit.
There were two affidavits filed.
Two affidavits filed. She did not disclose about the second award. She admitted the entire thing. Well, if I may, my lord, the affidavit filed by the collector dated 29 April 2025. My lord, may kindly see.
Yes.
Her entire contention is that, my lord, I come to the wrong forum. I should go to invoke a section 64 before the reference authority. That is substance of the reply of the collector. She did not disclose. There is no whisper. The award annexed by you is wrong. There is only a draft. Here is a final award. She didn't say. She didn't say.
Where?
Now, If my lord, can you see the paragraph 5 to 9, they talk about I should go to section 64. I come to the wrong forum. These are the pleading. And I will come to page number 13 of that affidavit, part of paragraph 15. Quoted section 27. Now, accordingly, my lord, the compensation was determined, and in terms of the final award, same was dispersed to the petitioner from March 24 till July. And kindly see till July, and the same has been admitted by the petitioner in their legal notice and such. Now, which final award? They did not disclose.
Final award will be the last award by which you pay.
But they did not. She did not disclose. But she just simply final award, and according to final award is that Fort May. And now the additional affidavit filed by the collector now. Now she has taken
so she does not disclose the final award.
Yes, she didn't disclose. She could have disclosed it and annexed it. If my first annexure is wrong, that because annexure is given by her, by the collector himself under the RTI. So she did not dispute, and that was rightly done. Now there's the additional affidavit which she brought now, the new collector now. My lord, can you see additional affidavit 10 July 2025 is filed by the additional deputy commissioner. Collector is not filing the affidavit also. I will show, my lord. It is first swear by the additional deputy commissioner. I will press the point out there also, my lord. Kindly see para 2 and 3.
Yes.
It is most respectfully submitted that the instant matter came for hearing on such wherein this order of record.
It's only to bring on record, it's not to make any averment.
But bring on the final award.
Yes.
Is it? Final award, which date, my lord? 19/2/2024.
Yes.
2024.
These things you will overlook. The thing is that only is brought on record. This is the final award 19/2/2024. Correct.
They say this is the final award. I would say this is not final award.
Okay,
My lord,
you can argue that.
Yes.
But regard to the authority, that's just brought on record by an officer. But doesn't mean that we cannot take cognizance of this document.
My lord will look into that. My lord will look into. But now let us see the content of the award. The ATM has brought now. Page number 4 of the same affidavit. My lord, may take point 4, page number 5.
Yes.
My lord, here they have mentioned the total area. Now straight away they have disclosed the market rate, market value. The early award statements, there was a breakup. The 7 types of categories of land, carrying different land values are there. Here nothing is disclosed. So the question is, how he arrived, how the collector arrived that this is the market value. It is apparent. Second one, my lord, second aspect, vital one, is that page number 6, point 14 itself.
Point 14.
Point 14. My lord, may kindly see additional interest compensation under section 33 of the Act at the rate of 12% per annum for 575 days from 010/2021 date of issue of the preliminary notification the sections and such to 045/2023 date of declaration award. My lord, kindly see payment taking up. Now this award date he has mentioned at the bottom, page number 6. According to collector now, 19 February is the date of award. Then how it is mentioned? If it is, my lord, 19 Feb is the correct.
Issue of preliminary notification, section 11.
Yes.
That is given as your date, 4th of May.
Yes. And if we go by the Act, my lord, in fact, the awarding a 12% would be effect from the date of the social impact assessment notification. But Meghalaya has introduced some changes, and it says that it should be from preliminary notification. So I will not dispute with that position. But beginning point is 4th May. Sorry, the 7 October is correct. But assuming that if this is the second award is the final award, then the collector would have mentioned the award would be 9 February instead of 4th May. Then the total date would be different. Amount would also come to different. I have shown in my table, I'll come to that point, inviting Lordship attention to that aspect of the matter. And the point 19, the last part, in the same page 6, the rate of compensation for the land was fixed as per the land valuation of the land submitted by the block development officer.
No, one second. Now you've been given from 7/10/21 to 4/5/23.
Yes.
That is the 12%.
Yes, they have given me the 12% interest with effect from 7 October 2021 to 4th May. If this is the correct one, they should have given me till 19 February 2024. They didn't do that. And the second vital aspect, my lord, this is not the award, because my lord, the section, my lord, it's section 25 of the Act.
Yes.
When the award can be made by the collector. The statutory time is prescribed by the Act itself.
This is an important point.
No pressure.
So your argument is that if they say that 4/5/23 is a draft award, then the interest should be from 7/10/21 to 19 Feb 24 is the final award, correct? Yes, and not 4/5/23. Then 4/23 just be a date of draft award. Then you'll be entitled to interest up to 24.
19 February 2024. They should have given me. But since my lord 04045 is the final award, they have given me the benefit of this only. But it is a statutory paper, but it is not a mere mistake. Now, why this is not final award is clearly revealed. Lordship kindly see section 25 of the Act. When the collector needs to pass the award. But then acquisition. Section 25 of the Act.
Yes.
May I read, my lord? Period within which an award shall be made. But it reads that the collector shall make an award within a period of 12 months from the date of publication of the declaration under section 19. And if no award is made within that period, the entire proceeding for the acquisition of land shall lapse. Now, provided that the appropriate government shall have the power to extend the period of 12 months if in its opinion circumstances exist justifying the same. Second proviso provided, my lord, that provided further that any such decision to extend the period shall be recorded in writing and the same shall be notified and be uploaded.
When was the section 19 notification made?
Section 19 notification is there, my lord.
When?
My lord, that one is, that one was, my lord, 9/11/2022.
So you should have made it within 11/23.
Yes. So therefore, the first award passed on 4th May was well within time. But the second award contended by the learned AG now, that it was passed on 19 February, is after 15 months.
But it doesn't speak of final award. Yes, the collector shall make an award within a period of 12 months.
Yes,
so collector has made the other award, which is the final award. Then the government has reviewed it and made the second final, had made the final award on 19/2. Correct.
But assuming that government has reviewed it, but that review and final award should be passed well within 12 months. If they cannot pass within 12 months, government can extend it in writing and notify that order to the public and upload it to the website. There is nothing as such. And this 19 February 2024 is after 15 months. It is not the case of the collector. The government has reviewed the extend the period, and thereafter I pass a final order. That is not the case of the collector. Even till the state is not filing a affidavit. So therefore, the so-called the second statement, award statement dated 9 February 2024 is not the award. But My lord, I just submit, my lord, the award, the collector needs to pass the award under section 23. And this award statement is supporting documents, introducing the breakup as to how the collector arrived the awards. The award statement could not survive alone. My lord. Award order is the foundation, my lord.
We understand your case. Your case is that till it culminated in the award 4/5/2023, the process was perfect. In the sense that there was section 19 notification in 22, then you had the meeting in 21, and then section 22, then you met with the landowners, then afterwards you published the award on 4/5/2023, correct? And even in your notice to the landowners to collect compensation, 4/5/23 is mentioned in the award. So what has changed, according to you, is that suddenly they have changed the amount. They have made another fine award. That is 19/2/2024, which is not corroborated or not supported by the materials that how they've arrived at final award. That's some substance. Then anything else?
Substance of that is our contention.
No, I mean, and you've cited the other things, with regard to the details given in 4/5/23, whereas no details are present in 19/2/2024 award, showing the exact assessment of land that was done. Right. And the second part is even the grant of interest should have from 21 to 23 only, to 4/5/23. So if had been the case that a final awards coming in 19/2/24, interest have been paid up to 22/24.
My lord,
that's your case, right?
My lord,
if I understand correctly.
My lord has got the point. I would show, my lord, with my objection affidavit for the time being.
No, now I mean, did anything else to add on top of that?
My lord, that is my argument. Therefore, the second award paper is not the final award. Even the first award, the award statement I annexed, that cannot survive alone. That is derived from the award passed on 4th May. 4th May. Therefore, the award order was passed on 4th May. And the collector prepared the award statement and given to the government for approval on 5th May. 5th May. So this 5th May award paper, which annexed in the writ petition, is part of the final award passed on 4th May. So that is the final award, according to me. According to me, it doesn't require for approval. Even approval is required. Government has approved it. Once government has approved it on 26th May, that becomes final. I've cited that authorities in earlier occasion also. In my lord, mechanism, my objection, if the contention of the collector is correct, that the second award statement brought by the collector is correct, then what would be the deprivation for the time being? I would show, my lord. I would straightaway come to
your objection.
Yes, my lord. Page number 5, ground, my lord, 4, Roman 4, may I take. I will leave aside other points. It is already there. I pleaded already. Page number 5. Point 4. Moreover, column 14 of the first award statement dated 5th May 2023, as well as column 14 of the second award statement dated 19 February 2024, has mentioned the same two dates, that is 7 October 2021 as the date of section 11 prelim notification, and 4 May 2023 as the date of the declaration of award. Thereby, both the statements specifically computed and mentioned 569 days as well as 575 days. In fact, 575 days is the correct calculation, madam. Days respectively. For the purpose of determining the additional compensation at the rate of 12% per annum under section 33 on the market value provided under section 26 of the Act 13. Admittedly, the date of the second award statement, 19 Feb, is correctly not mentioned at column number 14. Therein, in view of the admitted fact that both the above award statements were prepared as per the above same final award dated such. Assuming, though not admitted, that the second award statement 19 February 24 is accepted as the final award under section 37 as claimed in the additional affidavit, then the actual interregnum period from 7 October 2021 to 19 February 2024 for the purpose of section 333 would be 895 days, not
That point you
578
already
days.
made, yes.
In that even below paper would reveal.
Anything else over and above this?
My Lord would kindly see, in that case, my Lord, the total deprivations, page number 7.3.
No, you made your points, I mean, on facts, on a bit on law. So anything else you have to add to this, or we can hear the Advocate General?
My Lord, I'll let the other citation, Lordship permission, and I'll go to Report District and collect the
citations with regard to the new act.
With the new act. With the new act.
Yes.
With the new act. My Lord, this one, therefore, the total deprivation, my Lord, even assuming that collector second award is the final award, then they have to pay me more than 18 crores. We have calculated here.
On the interest?
On the interest. 12% interest.
Section 54.
No, my Lord, I have seen that one. It is not equal to section 20, section 64. I will cite that authorities. It is not required to go. Statutory benefits denial, my Lord, it is not required to go. But whenever, my Lord, with regard to measurement, with regard to inadequacy, my Lord, who entitled compensation, one can go to section 64.
Where the money has gone, to right person or not.
My Lord, that issue, my Lord, it is outside.
No, I mean that's section 64.
My Lord,
Where is your
my Lord,
citation?
Section, my Lord, I would cite. Well, at that point, it would be easy to say, my Lord, the respondents say that one person has received. It is not. Collector has transferred the entire account, amount in the account number of each landowners. My Lord, I've given to Rani colleague.
But see, no, the thing is that award which has already been signed by collector becomes an award as soon as approved by the government without an alteration.
Yes.
So, but it's not, in your case, approval is pending approval.
No.
So whether it becomes an award.
No, in my case, my Lord, the citation we made is under the All Act. Under the All Act, it requires approval. So the Supreme Court said the moment it is approved. No, therefore, my humble submission is that I cited this authority to bring home, my Lord, attention, seeking Lordship attention, is that even assuming that award is required to be approved, government has approved on 26 May. So that become final. So the award seem annexed by the collector now.
26 May, how do you see 26 May been approved?
It is the, I annexed in the writ petition.
Yes.
It is there. I'll just wait. My Lord, I need to take pain again to come to that approval letter. Page number 81 of the writ petition. I will not cite this authority had the collector not seek for approval. Therefore, I cite because he was seeking for approval. Page number 81. Of the writ petition, Annex 12. But returning here with a draft award received by your letter, there is reference. I'm here to say that approved valuation of compensation of the award in respect of the above mentioned project is per below. So they have approved on 4th May. So even assuming that, my Lord, then as a 4th May is not the date of approval, I would follow the collector. But the moment the government has approved on 6 May, 26 May, it becomes final. So the second award statement annexed by the collector in the additional, if it is wrong, even on this count alone. In earlier occasion, I have already cited that collector has no power to review.
So this 717 crores is the correct amount?
The correct amount.
Yes.
That is correct. Government has approved it.
Is he a competent authority?
Well, this was approved by the government, as sought by the collector.
Yes.
And the affidavit filed by my learned esteemed colleague, Dr. Mbozika, for NHITCL, they have admitted, yes, award was made, but we found that the award amount is not justifiable. So therefore, NHITCL, Ministry of Transport, has every right to seek for review of the award. So they have admitted.
Okay.
There is an award. So I will not take my Lordship attention. The second citation, the citation I want to place, earlier citation I already made, I will not repeat. With Lordship permission, if I cite only
2019.
Yes. Well, Well, 2000.
Show a case where the award has been reviewed. I mean, that's for the other side to show. Show a case where there has been a draft award has been reviewed, and what circumstances the review is done.
Let them justify. According to me, my lord,
you cannot review.
I cannot review.
Once it's made, it's made.
One is made, is made. It is not.
Judgments may come later, my lord. We will place our case is very clear, my lord, from the act itself.
Okay, let them.
So judgments will. The judgments are not applicable, my lord. We will place them then.
I'm not. The court's not really inclined because they're all 1894 judgments. I mean, they are referred to the old act.
My friend is not referred to the most relevant section of the act, my lord. And the award is not.
Okay, wait, we'll come there. Let him finish.
I'll come to that.
Judgments you can read later on. These judgments are not relevant.
I would come to that section 20, finality of the award. My lord may take pain again to look at section 37. Awards of collector when to be made final, to be final.
Yes.
It says the awards should be filed in the collector's office and shall, except as hereinafter provided, be final and conclusive evidence as between the collector and the person interested, whether they have respectively appeared before the collector or not, of the true area, market value of the land, and the assets attached thereto, solution so determined, and the apportionment of the compensation amongst the person interested. The collector shall give immediate notice of his awards to each of the person interested who are not present personally or through their respective when the award was made. This was never given to me. Even RTI was made, they didn't provide. The collector shall keep open to the public and display a summary of the entire proceeding undertaken in the case of acquisition of land, including the amount of compensation awarded to each individual along with details of the land finally acquired.
36. 30 and 36.
But I'll come to that. Yes. Under this act on the website created for this purpose. Now, therefore, according to me, my lord, award would be conclusive when the entire award was passed containing the executed area of the land, apportionment, my lord, including the solutions. Now, when collector has done this, collector has done on 4th and 5th May, and government has approved it. Government approval includes solutions, the areas, my lord. And 36, my lord, power of the government. My lord, I would show that the government has no power to review also. To, my lord, tingle with the award passed by the collector. 36 is the power of the power to call for records. The appropriate government may at any time, before the award, my lord, might keep it. Before the award is made by the collector under section 30, call for any record of any proceedings, whether by way of inquiry or otherwise, for the purpose of satisfying itself as to whether the legality or propriety of any findings or order passed or as the regularity of such proceeding, and may pass such order or issue such direction in relation thereto as it deem fit, provided that the appropriate government shall not pass or issue any order or direction prejudicial to any person without affording such person as a reasonable opportunity being heard. Now, therefore, the government can exercise this before collector pass the award. Once he passed the award on 4th May, and preparation of statement was made on 5th May, and sent to the government, government has no power to call for the records. And therefore, the subsequent the government interference, seeking a review committee and direction to the collector to review the order, is beyond the scope of this act. The act doesn't permit.
Yes.
But therefore, the citation I want to show that how the award has been concluded. May I cite 2021 volume 3, first 21 volume 3. May I cite how the ascertain whether the award has been passed or not. Here also, my lord, in this case also, award was passed, and the authority asked for placement of the remaining fund to be paid to the landowners, and the contention came up that the award not yet passed. So Supreme Court examined the matter and passed its order. We take a relevant paragraph, my lord, paragraph 15 and 16. Paragraph 15 and 16, Your Lordship, permission. May I read? Your Lordship, get it.
Yes.
Paragraph 15. This letter dated 5th March was issued in response to the letter dated and such, wherein on the approval of the award and the land acquisition estimate was sought. While this letter only expressly mentions the land acquisition estimate and not the award, a combined reading of this letter with the preceding letter dated and such, and the subsequent conduct of the parties, including the first respondent, make it evident that the award stood approved by these letters and such. It is noteworthy that copies of both the letters dated and such were also addressed to the Industries and Commerce Department of the Government of Assam. By the initial letter dated and such, the State Department was requested to arrange the balance funds for making payment to the land
But in
owners.
this case, they already went through the entire approval process and they asked for arrangement of funds. It's not similarly situated.
In my case also, my lord, after collector has the government has approved it, collector asks the NHIDS to place the remaining amount. But my lord,
It's not the remaining amount, it's just that amount is not paid at all.
No.
Everything happens subsequently.
No, my lord, I'll just say, Lordship may bear with me.
Page 81.
May bear with me, that letter is very important. Lordship has correctly pointed out. But page number
81.
My lord. Page number 84. After government approved, the collector sought for depositing the remaining balance. May I read, my lord, with reference to the subject cited above, page number 84.
Yes.
But I'm to enclose here with letters received from the Joint Secretary to the Government of Meghalaya Revenue Disaster Department being approved valuation of the compensation award for construction of such and such, which be shorter of the Shillong Western bypass for an amount of rupees and such. In this connection, an amount of rupees 3 crores has been deposited from your end in the banks and such Shillong having joint accounts and such. Therefore, you are requested to deposit the balance amount of compensation, my lord, as mentioned below, to enable this office to initiate the payment of compensation to concerned landowners. So exactly, my lord, Supreme Court ordered the same thing, my lord. When Supreme Court said the conduct of the parties, and even page number 85.
By the collector.
It is by the collector requesting the NHIDCL to deposit the balance amount. So if it is a draft amount, collector will not do that. Since it is the final amount, collector said the final amount has been, government has been approved it, that the balance amount kindly deposited so that I can release it to the landowners. Exactly the Supreme Court para 15 and 16, the same, my lord. The same was Supreme Court has examined the conduct of the parties. It is not put in the middle. The copies of both the letters were also addressed to the industries, Government of Assam, 5 letters and such. The State Department was requested to arrange balance funds for making payment to the landowners as per their award. In furtherance of this, letters instances that the State Department was directed to place the balance estimated fund at the disposal of the Deputy Commissioner. It's the same order, same thing. Supreme Court said the conduct of the letters, everything showed that yes, award has already been passed. In my case also, my lord. And the other judgment may I please, my 2022, volume 2 ACC. Relevant para with lordship permission, may I think para 27 and 55 would be relevant.
Para
27 and 55. running page 789.
Paragraph 27.
27. My lord, Section 31 of the Act enumerates that the collector, having determined the total compensation, shall, to arrive at the final award, impose solicium of an amount equivalent to 100% of the compensation amount. As per Section 33, the landowners, in addition to the market value of the land, entitled to an amount calculated at the rate of 12% per annum, commencing from the date of publication, such and such. Now, I just want to bring that, well, collector award can be made final when he made the solicium and interest, including together. At page number 50, para 55, more elaborate matter. That is running page 799. Page. Here it talks about the limitation also.
Yes.
Subsection 1 to section 37, where my learned friends has pointed out, 37 of the Act, as well as subsection 1 to section 12 of the 1894 Act, state that award shall be filed in the collector's office and shall be final and conclusive evidence as between the collectors and the person interested. It would not matter whether the person interested have appeared before the collector or not. Further, the award is final and conclusive evidence as of the true area. Subsection 3 to section 37 of the Act requires the collector to keep open to public and display summary of the entire proceeding undertaken in the case of acquisition of the land, including the amount of compensation awarded. These mandates must be complied with, but as they are post the making of the award and therefore would not affect the validity of the award when made within the statutory time. It's very important, madam. Issue of notice by the collector to the person interested, which is to be given to the person not present or personally or through the representatives when the award is made, is to be issued immediately, but the issue of notice is not a condition precedent for making the award. Belated issuance of notice would not therefore legally affect the validity of the award, though there may be some other consequences. Equally, the limitation period to challenge and question the compensation awarded would commence on the service in intimation about the making of the award on the landowners. Be that as it may, when satisfied that the award was made published within the prescribed period, even when there was backdating of the award or delay in effective service or effecting service on the landowners, the land acquisition proceeding would not be set aside. But I want to emphasize, my lord, here it says it is the importance of the passing of the award within the time. Admittedly, I have shown the second award statement is beyond the time. And the last one, my lord, let me just cite well, my learned friends say that I should go to reference forum. Madam, hey, please. Here also the issue in the Supreme Court, the interest under section 19, section 1824.
Reported somewhere, or reported. So 18.
It is reported, but somehow it is missing in my library, therefore it is downloaded. But it is a reported one. But the reported relevant citation is there, my lord. I would please.
What's the citation?
The citation book. Yes. It is there. Union of India versus.
You were there all along, or you just came just now?
My lord, I may take a section, para 36, 37, and 38, my lord. Well, Supreme Court say that all the disputes under the Land Acquisition Act is not required to go to the reference authority. But 36, in our considered opinion, the dispute relating to non-award of interest to the landowners, whether under section 28 or 34, is not the dispute which falls under section 18 or under section such of the Act. In other words, a reference under section 18 can only be made by the collector in respect of those issues which are specified under section 18. A dispute relating to non-award of interest payable to landowners under section 28 and or 34 of the Act is not specified under section 18 and hence it is not capable of being referred by the collector to the civil court under section of the Act. It is also for the reason that payment of interest is statutory in character, and being statutory, it is mandatory for payment once conditions specified under section 28 and or 34 are completed. It is true that once the interest is awarded by the court under section 28 or by the collector under section 34 of the Act, it becomes a part of the award. However, it is hardly of any significance and has no bearing for deciding the question of remedy to challenge issue relating to non-award of
interest. Interest relation, that is all statutory. So I mean that is not a question for determination. So once award is made, then interest is.
Therefore, when I point out the
now
missing.
Yes, we understand your case. You know that it has been approved. Request for default balance of funds been done. The entire process has been completed.
Yes.
You can't arbitrarily just.
Exactly. And before.
Give me 5 minutes. Yes.
Right.
Anything else?
I would open the report, one petition in the report district. And the rest, my learned AG and my colleague can give it. My lord, I will make it as brief as possible. The report district, my lord. That is WPC number 475. 475, my lord. Altogether, my lord, how many questions? All are connected, my lord.
How many
report districts? There are 305 landowners are there. My lord may keep it. My 305 landowners, and here, my lord, 50 of them are before my lord in the writ petitions. $305 landowners, and out of this, 500 are before my lord today.
50 are below before.
Yes, 50 of them are here. My lord, I may take us away straight to Annexure 1, page number 23A. Section 21 notice was issued. Page number 23A, Annexure 1. 23A. Here they have mentioned that the declaration of Section 19 was on 7 December 2022. It is mentioned. So they fixed the date for inquiry on 10 March 2023. So accordingly, the next page, 24, Annexure 2, on the day of the inquiry, some of the writ petition also appear. Well, and thereafter, page number 43, the NHITCL manager has written this to the Executive Project Director, 15 June 2023, highlighting that the budget of the Union of India, and they saying that the estimate given by the DC collector Iskhasil is higher than the budget. May I take, my lord, page number 44, the breakup is there, the package for page number 44, serial number 1, my lord, 12.8 kilometers is the package number 1, is for Repoi district. And point number 4 of that point 5, cost of land acquisition rehabilitation, my lord can see in the emitter. Number 1 is the 12.8 kilometer is the Repoi district first package, and the cost of that first package is mentioned, my lord, 0.5 of that para 4, 200 crore. This is the budget estimated by the Ministry of Transport.
No, we're reading 0.5.
0.5, my lord. Para 4, para 4 of 0.5 of para 4. Madam.
Okay,
cost of land acquisition, rehabilitation and resettlement.
Package 1 is it's Repoi.
Repoi.
Package 2 is Iskhasil and package 3 is?
Yes. So
package 3 is where?
Package 3 is for package 2 and 3 is for Iskhasil. Longer kilometers.
2 and 3.
Well. And page number 45. Point number 6, para 6, I may say, para 6. Para 6, approve final award They have mentioned this is related to East Khasials. In fact, I've indicated earlier also, East Khasial method. Now, page number 47, para 15.
The final award is as per which amount?
This is for the East Khasials.
Is as per 4523?
Yes, the one we have dealt with in the first case.
As per 4523?
Yes, that is the one.
Then?
That is the one. And my lord may come to page number 47, para 15. Here the budget for package 1 is reproduced again by the manager. It is pertinent to mention that the sanction cost towards land acquisition, rehabilitation and resettlement as approved by the MORT are 200 crores for package 1, 255 for package 2 and 226 for package 3 respectively, which is on the lesser side as the instant final award land acquisition is rupees and such. He is referring to the East Khasials. He do admit that, my lord, therefore I said the final award is there. Final award. Now, in view of this, para 17, in view of the above, the remaining amount of rupees and such, out of the final award amount of rupees and such, is recommended to RO for approval of competent authority for transferring the land acquisition as per the existing provision of the amount under Land Acquisition Act, respective packages. Remaining amount may be deposited as and when RCE for respective packages are get approved by the competent authority. So he has written to the project director. So he did not dispute. He never said it is a draft amount. It is a final amount, therefore he said this. Now in view of the para 49, my lord, they approved by the government with regard to Ripoy district is there.
Revised cost estimate will be submitted.
Yes.
Yes.
So his substance, he pointed out that the award prepared by the East Khasials collector is higher side, after referring to all the packages, but it requires to be deposited. Now, page 49 is the award with regard to the approval of the award passed by the government on 18 August. It's a reference your letter number censored 25th May 2023. Now, in returning here with the draft award received by your letter under reference, I'm directed to say that the approved valuation of the compensation award in respect of the above mentioned project is as per stated below. So detailed breakup is given, and the serial number 8, point number 8 is the total amount of compensation. Number 8, 494 crores, 97 crores is the compensation amount. 497 crores, 46 lakhs, 6,800.
Where did you from?
My lord, page number 49, point number 7 in the table.
Additional amount?
My lord. I'm sorry, point number 8, my lord. Total amount of compensation. Point number 8, my lord. So compensation is 487 crores, and establishment cost is taken by the government. This is also mentioned there. Now, my lord, may kindly see this important. Page number 49A, the next page. I see it is a final amount, a final award. The reason is very clear on the face of this paper also. It says, after all the formalities are completed, kindly inform the government of the following: date of disbursement of the land compensation, date of handing over possession of the land, name of awardees received the amount of compensation under protest or otherwise, whether the landowners received the amount of land compensation under protest or otherwise, to indicate whether establishment contingency charges have been realized at prescribed rate and deposited to the appropriate head of account, that is such and such and such, to indicate balance amount of compensation refunded to the requiring department, check such and such. So government is very clear that is the final amount, so you go for this person. If it is only approval, the draft approval, government would never say. Same thing they had done in the East Khasials approval also. Now thereafter, my lord, page number 50 is about where after everything is done, the government start involving, calling a meeting. My lord, page number 50 is the meeting. They say they have to review. My lord. It says that Commissioner and Secretary of the Government of Meghalaya, PWD, informed that the review meeting such and such Guwahati, the Honorable Minister Zanzar observed that the final award is kindly marked, final award of the land compensation for Shillong Western bypass is on the higher side and not appropriate with the civil cause, and directed the state government to revise the cause of downwards within a month's time, or the project will be dropped. Well, it seems like an ultimatum, but they have made the preparation, cost preparation in Delhi, they can do it, but the reality of market value is known by the collector. He's the man.
You see, the thing is that we don't want to go there.
Right.
But the thing is that if you're not satisfied, notwithstanding the process, then you have recourse to seek enhancement.
My lord, this is not, my lord. Therefore, I was.
Now you want a shortcut because you see that since the amount's already there, the procedure is all correct. Now, so pay me the amount. So you want a mandamus to direct them to pay the balance amount of something 200 crores.
Yes. That is my case, madam. If it is, madam, they fix 5 rupees. I say it should be 7 rupees. I should go to reference court. But here, my case, he fixed 5 rupees. On the day of delivery, he delivered 2 rupees to me. That is the grievance, madam. Well, thereafter, what happened? My lord, page number 54. 54. Government directed the collector to revise. Is available there. Page 54. Addressed to 2 collectors. Where it says, madam, with reference to meetings held on 4th December and 7th November on the cited subject, it is observed that direction issued instructing Deputy Commissioner to submit a revised course of land acquisition near about the amount as per Section 11 on or before such and such is yet to be received in this office. The urgency and importance of the matter was clearly made known to the Deputy Commissioners during the meeting, and for which necessary action was awaited. However, it appears that the same has not been taken seriously enough, inviting possible ramifications which are not acceptable. You are therefore requested to submit the revised estimate immediately to this office on or before such and such. So it is ultimatum given by the government to the collector, and that was a review take place. And after that, he issued a payment notice. Payment notice is Annexure 7, page number 55. Here, I would point out the stark deficiency, my lord. Here, when he issued a payment notice, he did not mention the amount of the compensation I entitled. Nothing is mentioned.
In this page,
in this page, yes. So how the citizen would go and protest? They just simply 100% compensate in the meter paragraph. As per government notification, such compensation to be released to the interested person at the rate of 100% of the total compensation. So it would be difficult for the landowners to go and protest. But they submitted the paper, and they would show my lord only 2 annexures and go to the contention of the NHCL. My lord, I put up the RTI, page number 91. And specific query was made, my lord. In pursuance thereto, my lord, they have given a, my lord, I would not go to representation also there, I would skip. I would come to the RTI reply in response to that RTI application.
Which page, sorry?
Reply would be page 108. 108. We asked for specific award sheets, my lord. Detail we asked, but they didn't provide. I'll show you some paper they provide. But for serial number 4, copy of the Section 11 notices, which I have shown. And serial number 5, it says, well, copy of the order passed by the collector fixing the market value per square feet or square meter of the land acquired as determined from the date of notifications and such. Determined as per government land rate of report district for the probable estimate during the such and such. They don't provide. We ask for the copy. Please, if you don't want to show others, but show me my award paper. They don't show. Now, 7 copy of the attendance sheet they have given. Section 21 inquiry.
Section?
My lord. Serial number 6, my lord.
Exempted for disclosure?
They say, my lord, this award paper we asked for. They say it is exempted. Whereas the section...
You filed an appeal against this?
But we did not file bail.
Then?
We filed a writ petition before this court.
No, I mean regarding the disclosure on 8.1, now you've gone for the PIO, do you have a forum for appeal?
No, but that is
departmental or CIO?
That is there. Right, that is the matter.
But you didn't do it.
However, they did not.
But then this reflect nothing. This RTI is nothing.
Yeah, they didn't provide us detail. Now, therefore, before I take to the additional affidavit filed by the London HG, the affidavit filed by the NHITCR also same thing, dated 4th July 2025.
In the writ petition?
In the writ petition. State did not, my lord, file. State and collector did not file affidavit here at all, saying that it is a cover case with the East Castles matter. They didn't file. However, the NHITCR filed it. So, para 4 is admitted. May I just take a para 4? Will not invite my lord's attention to para 4.
Yes.
It says, with regard to the statement made in paragraph 6 of the petition, the opponent state that the land acquisition and the determination for the land compensation was carried out by the Deputy Commissioner Collector. East Castles should be it should be a report district, a typical mistake, under the land acquisitions and such. The awarded amount for acquisition was significantly higher than the allocated budget for this purpose. Hence, the same was highlighted and communicated to the NHIT headquarters. The internal communication within the organization is the matter of record and not of acceptance or rejection of the land acquisition compensation award. Ministry of Sanjaj MORT and National Highway at Sanjaj, being the primary project funding and executing body, are fully within their rights to carry out review of the award amount, especially in cases where the award lacks a justifiable basis and is disproportionately high as compared to the amount submitted at the time of sanction of the project. In the instant case, the award amount was excessively high, even surpassing the total cost of construction. So they admitted that it is a final award. So how the collector say that it is not final award? Now I would come to the affidavit filed by the additional affidavit filed by the collector. Then I would raise my argument. My lord, the additional affidavit dated 10 July 2025. He was a collector. He also the additional Deputy Commissioner has filed the affidavit, not the collector. Anyway, para 2 and 3 say it is a final award, and date of the final award they mentioned 11 January 2024. I would come to the award sheets, the award statement. Award statement they did not provide on the RTI, but now they have annexed this. But page number 4 is the now serial number 3. The date of declaration they have mentioned, my lord. Section 19 declaration was made on 7th December 2022. It is a vital, my lord, when we make we examine the
712.
My lord, 712. This will be relevant, yes, my lord, whether the second award statement is correct or not. When the situation area extend, no, serial number 4, detailed breakup is not given. Value of the land, they don't disclose it. Now may I come to next page, point 7. Amount of compensation allowed for the land itself without trees and such. The market value it came to 49 crore something without multiplying factor. Now I would come to my lord serial number 13. This is very important. 13, my lord. Plus additional compensation interest under section 3 at the rate of 12% per annum for 539 days from, my lord, is important, 3rd December 2021, the date of publication notification of preliminary notification, to 25th May 2023, date of declaration of award, payment taking over. So now, here the next page, now this is contending that no, that is not the date of the award. Date of the award is 11 January. The next page, page number 6. That is absolutely afterthought documents.
Page number 6?
Page number 6 at the bottom, my lord, date of the Nongpo 11, 2024. Whereas the serial number 13 is clearly mentioned that the date of the award is 25th May 2023. And thereafter, my lord, the review took place. They reduced them.
Where's the draft award here with regard to Kriboy?
Well, they didn't provide us copy. They didn't show. Even now that they're not annexing. Assuming it is a draft award, where is the draft award?
That the date they've arrived at, and but the date they've shown in the additional affidavit?
Yes.
That should be the date of the draft award according to them.
According to them. But it is not there. Well, not me call for the record also. What they have maneuvered is my humble submission with respect.
The other maneuver, just that they just try to bring it within the budget proposal. That's all. Because otherwise, if they hadn't done it, the road won't, like you won't got 1 rupee also.
My lord, and the final estimate, the award passed by the collector is less than the award, less than the budget also. The policy, my lord, the petition number 1 is projected as a scapegoat anyway, my lord. But think about the remaining, my lord, the rest of the landowners. The land was in the village.
He's got 80 crores, right? That's petition number 1.
My lord, he has a huge plot of land.
In one case, man.
A huge plot of land, yes.
Another case also got 40.
He has a huge plot of land. He's the number 1. The rest of the others, for example, and they all of them receive through their bank account. So think about, my lord, when I think about the other remaining landowners, my lord, they lose the land.
Even then, now when with the revised award, 1 square meter came to how much?
They didn't disclose. They're not showing.
Everything is disclosed, Let me.
I would conclude. I would.
Suppose we say arable land or whatever, and 5,000 was assessed per square meter, and what is the new assessment made by them? It'll come to how much?
It is there, It is there, I saw, when my turn comes.
Let the learned age issue. Let it learn issue. But my humble submission before I raise, my humble submission is that the award was passed by the collector in accordance with law, but only because of the pressure from the higher authorities, compelled to review whatever changes in the take place, and therefore it is more than a mere arithmetical rectification. But the Land Acquisition Act permits for clerical mistakes, arithmetical mistakes. It is not the arithmetical mistakes. Substantial change of the award itself. Therefore, my humble submission, my lord, land acquisition.
It is only given there in the affidavit of HIDCL. It said that the proposed amount given by the Deputy Commissioner in the final award is way beyond the project cost.
My lord, that is.
And even so, like it makes it unfeasible. So if that is the cost that is projected, that means the project won't come through.
No, my lord.
That means petition number 1 won't have 80 crores in his pocket right now. He'll still be doing farming there.
Right. My lord, throughout the proceeding, my lord, NHIDCL was involved. At the time of preparation of the award also.
The projected cost was given. The thing is that now, how is the court to examine other ancillary, this and other factors which have influenced or have arrived at this decision? That's the only thing.
Right.
Whether it's valid, bona fide,
yes. Right.
Whether the law permits it.
Right. My humble submission, therefore, I cited the authorities, Lordship permission earlier. The law doesn't permit. To decide the award is the prerogative of the collector.
Yes. Lordship, the issue in my submission before your Lordship is what my friend is saying that the order of the collector should be estimate on 4th.
Well, may I just point out, man, before each permits, in my objection, even assuming that collector second award is correct, when we count the interest, there is more than 3 crores of deprivations are there still there. I just pointed out, man.
Oh yes, no, that this court's noted because they are paying interest up to 4/5/23, the date of what they see as a draft award, right? While the final award is 19 February 2024.
Yes.
Yes.
The issue in my humble petition is in the writ petition, what they are saying is that the order passed by the collector estimating the cost of the appeal is an award. And therefore, it is a final award and it cannot be altered by the state government. That's the sum and substance of the argument.
Yes.
Now, in order to ascertain whether the order of the collector dated 4 May 2023 is final award in terms of section 37 is or not, I need to show 3 provisions of the law, and this is section 23 first.
Yes.
On the day so fixed, or any other day to which inquiry has been resolved, the collector shall proceed to inquire into objections, if any, which any person interested has stated pursuant to notice given under section 21, to the measurement made after section 20, and into the value of land at which value of the land at the date of publication of notification and into respective interest of persons claiming the compensation and rehabilitation and resettlement, and shall make an award under his hand of a true area of land. B. Compensation as determined under 27 along with rehabilitation and resettlement award under 31, and which in his opinion should be allowed for the land. And C. Most crucial, apportionment of the said compensation among all the persons known or believed to be interested in land, on whom or whose claim he has information whether or not they have respectively appeared before it. So these are the three requirements for preparing the draft award. That is C, apportionment. You also may kindly mark the apportionment. Now kindly see, on the basis of reading of section 23, the draft award, which was our final award as per the petitioner, which is at page 76. Kindly see that. This is also kindly see page 76 and annexure 10 of the petition side by side of the East Kashmir district. 474.
No, it is.
Page 76. I will show from East Kashmir district, and then I will give you lots later on. 474. Sorry, page 76 annexure 10. Lordship has the annexure 10 at page 76.
Yes.
Now, Lordship, kindly see, this is the order sheet, internal order sheet of the collector. It is a file noting in the collector's own file. Now, what it says, Lord, if you also will see, real number, date is 4th May 2023. In letter number so and so received from manager NHIDCL with a request to submit the final award under section 23 after approval from the state government rather than submission of probable cost. Hearing under section 21 and 20 already conducted at Soyon block so and so villages and the land was originally land. Prepared the draft award according to added the mandatory solution so and so interest from the preliminary notification. So it is written it is a draft award admittedly. It is said that it is a draft award and with the permission of the state government. Your Lordship kindly note this, that this is the draft award. And your Lordship has seen that in the section 23 subsection 3 requirement is of apportionment of the land and cost everything. Right now this is a kind of revised estimate because collector has to get the estimate approved. Approval of award is different from estimate. Money will come from the state government. Your Lordship has seen 23C3 is very clear now in 23C apportionment. And I will show the final award.
So see now, it does not say that as per the what do you call it? Is apportionment with said compensation. Apportionment means after the rates have been arrived at, suppose arable land, ABC, categories of land. Now apportionment means yes.
Yes, you also can see the final award. There it will be clear. Final award which we have placed along with the affidavit. Can you see the final award? At page 4, award starts.
Page
4 of my additional affidavit.
Our statement.
Yes, and for 19th February, and kindly come to page 7.
1 second. February.
Yes, 7 Lordship. Kindly see the heading of the page. Apportionment statement for 2 lane with paved shoulder of Shillong Western Bypass. And your Lordship will see name of the owner in the first column, serial number 1, owner's name, parcel of land, village, right of change from 2 to, and the area, total right.
So where is page reading? 1 second.
And
Page 4.
page 7, page 7 of the additional affidavit.
Oh, the table.
Table, can you see page top of the table? It is mentioned, it is apportionment statement for 2 lane with great shoulder of Shillong Western bypass.
So you see it's under 3, it's under 3C.
Yes, 3C, 23C. Now you also will see, kindly see the rate, area, everything. Now name of the owner is mentioned in the serial number 1. Then parcel of land is mentioned, dwelling is mentioned, right change is mentioned, right of way area is mentioned, rate per square meter 1250, kindly 1250. Amount of land, market value, then amount of compensation, solution, interest, and the total compensation. So this is how, and each and every aspect has been, market rate are also given in this clearly, and if you want to say the market rate varies from the place of land and owner to owner. If in the entire column, initially 100, 250, then after that 1510, and it also goes to 2400 at the bottom. So the market rate is also mentioned, apportionment is what was being shown by friend of 4/5/2023. It was a kind of estimate because ultimately collector has no money. He has to get the money from somewhere. Collector is preparing the draft estimate, and in draft estimate on 4th May 2023, he is seeking approval of the authorities. And this is the draft estimate, and please give the approval, etc. Then, and my friend,
So you mean to say that this is a detailed, minute, micro estimate of every holding? Compared to the draft estimate, which is a general of arable land and ABCD categories.
I'm grateful, that is my submission, and my friend, if you want to see in terms of this notices have been issued to the parties. If I just
one second. So this document was appended to the award statement, you mean?
Yes.
So the argument that Mr. Changreshwar has made that at number 14, that's at C 14, that no details have been given is not correct.
Yes, and I also substantiate my contention or my submission before the lordship that based on the notices which are issued to individual landowners also.
Yes.
At least see.
One second. And the first case in the country of this type. Yes.
Can you see the RTA application which are shown, and then the notices have been issued to awardees in that case 97, and we come to repetition.
Let us finish with this first. So your statement is that this award statement is under 3C.
Yes.
Apportionment. And apportionment is under 3C. Then and payment was made in accordance with this apportionment.
Yes, Milord. And that is what I wanted to show, Milord. 97.
Okay. At least we have to understand because
Yes, Milord.
Pay 97 rate petition.
Yes, Milord. Accept to be clear.
Yes.
If you want to kindly see page 97. And in 97, you want to kindly mark the date. Date is date of award you also have already noted, 19 February 2024. And after this, if you want to see at the top of the page, notice 97, notice under section 37 of GIA. So award you also by saying 37 is the finality.
Yes.
If you watch it to section 37 after showing this notice.
Yes.
Notice under section 37 of the RFCTLARR Act, construction. Mr. Kawa, here by notice you have treated as a person of award. This is a psycho-style, Your Lordship, but the Lordship 19 February, immediately after 19 February, on 26 February, it was sent to him, and the award, and in this connection, you are appeared to person on so and so and collect the amount, etc. Lord, the amount of this amount in terms of this award has been collected by the petitioner without any protest.
Yes. What about the date shown there, 4th May 2023?
Because we not a cyclo-style, because what collector did on 4th May, he circulated and he prepared those kind of cyclo-style in all matters. So Lordship will find everything is 4th May. Even in Riboi or Lordship also, Lordship has rightly and correctly observed that because of this typographical error, draft award will not become final award. Final award is one which is under 37. Notice is under 37. Your Lordship has to take note of the fact. The notice under section 37 because 37 is the final award, conclusive evidence between the parties. And in terms of this conclusive evidence, Mr. Kava has 40 and odd crore rupees. 40 and odd crore rupees immediately after the final award on 26 February. And kindly see 37 now in this slide, 37. Because 23 will also be meaningless because award is under 37 only. Whatever is there, it is 37. Because there is a statutory provision about the award, that whatever is, because before 37 everything can take place. But 37 says that this is final and this is whatever is filed before collector is the final award. Before that there can be 10 processes. The award shall be filed in the collector's office and shall, except as hereinafter provided, be final and conclusive evidence. So what is conclusive evidence? Is the award which is filed in the office of collector under 37, which I have shown at page 97. So that is the conclusive. Now my friend can't go back to stage prior to 37 because law says whatever is there in the 37, it is a final award. As it says, it's a final and conclusive evidence as between the collector and persons interested, whether they have respectively appeared before collector or not, of the true area and market value of land and assets attached thereto, solution so determined and apportionment of compensation among the persons interested. Collector shall give immediate notice of his award of such persons interested who are not personally present through respective as their representative when the awards are made. Collector shall keep open to the public and display the summary of entire proceeding undertaken in case of acquisition of land, including amount of compensation awarded to each individual along with details of land finally acquired under this act on the website created on this process. Lordship has seen the award apportionment statement, name of each individual, their land, the market rate, solution, amount, and payment has been made.
Yes.
Payment has been made. So 37 Milord is the finality. 37 gives finality to the award Milord. That is clear. So once 37 is there Milord, the question of the other things may not arise. Question of if your Lordship will see Mr. Thaba's if Lordship kindly come back to the award Milord. And at page 8, find the award which I find additional document, additional proven in the example given. And is the
yes.
Is the apportionment statement.
Number 12.
Number 12. 3 days Singh Tawa, his land is mentioned, and the final award is also mentioned 40 crore 85 lakh 22,662. So if he says, if Mr. Thabar argues for your Lordship that look, this award is no award in the eyes of God. Final award is, so he was not entitled to 40 crore rupees also. Which he has received it without protest. My friend can say anything coldly. But with greatest of respect to my friend, you can't come and say openly that look, I have protested, it was transferred to my account and therefore I have accepted the amount. Accepted the amount, appropriated the amount, and you say now I want higher, better cake and I want to have the cake and eat it too also. Lordship, kindly see.
Also the not only the cake needed to even the bakery and the baker. Then.
And if my friend is not active project, if he should return the money, and he says that look, the argument is that the entire proceeding had lapsed because it was not within 1 year. He could not have taken this one. Now we are not coming back to the legal issue.
No, you stick to the core issues, as whether there is power, notwithstanding the other circumstances or exigencies that made you reduce amount of compensation. Now, whether there is power vested in you by law to review and to reduce the rate of compensation that has been awarded after a public meeting.
Yes, sir. So the question which falls for Lordship.
Final award, yes, 37 final award, but whether in arriving at the final award, whether the process is irregular, that's the only thing. Judicial review will, just be that only. Whether the steps taken by the authorities or all the respondents, the decision-making process is above board, that's all.
Yes. Now, the Lordship has seen that in the...
Yes, facts, I think, there's more or less, I think, not at odds anyway, yes.
Yes, sir. So the legal question which you are writing, that and posed, that whether in this entire process, the estimate prepared by collector could have been reviewed by the state government.
Yes, taking into account that the new act,
and yes,
doesn't speak expressly about approval, but your rules do.
Yes.
That's the only thing.
Yes, and rules, and your Lordship has taken note that rules are not under challenge. Rules can fill the gap also, rules are not under challenge. My friend has not challenged the rules. But I am not going that route, I need not go because facts will also demonstrate that I cannot take that resort to rules. Facts will demonstrate that in a project, if there is a project concerning any district, in a project the estimated cost for the project is 400 crore rupees. Collector says that in his estimate it may go to 600 crore and 700 crore rupees. Collector approaches me and I will show those approaches the state government that look, as per our draft estimate, we are having this kind of figure, and therefore there is a dichotomy in your project and the estimate which is coming. Now, if your Lordship has seen that page 94 of the writ petition, what is the document which we have given 94? If your Lordship kindly come to 94. Because it's a question, this is an estimate which is being discussed between the various organs of the government, because it requires the outflow of money, because if the cost is too much, then project could have been saved, page 94,
Yes.
And meeting of 4th, subject matter relating to land acquisition of Ceylon district bypass. Meeting on 4th December under the Honorable Chief Minister's consent. With reference to meeting held on 4th December 23 and the subject side is observed that direction issued instructing Deputy Minister to submit revised cost of land acquisition near about amount of section 11. All reports also is yet to be received in this work. The urgency and importance of the matter was clearly made known to Deputy Minister. Which necessary action was made, or directed the same was not been taken. You are requested to submit, kindly mark, revise estimate immediately to office of So what is being discussed between the parties as to the estimate of the cost of acquisition.
Yes.
And the market, if you have seen the award at page 7, market value of land with a factor of 1/1 has been taken, because sometimes the video goes beyond and he gives his own estimate of the land without realizing the correct manner of estimate. Lordship has seen litigation also in relating to land acquisition of airport in India. So it was inflated, it led to, so there is a check and balance method. If somebody at the government functionary at the lowest level goes and says that look, this is going to be the rate, then there is a discussion between the various wings of the government, and they come to the fair conclusion and fair compensation. After the award is made, what is the remedy? Suppose the award is to the detriment of the person whose land is getting acquired, then he had remedy under section 64, and you see section 64 in this regard. He can't come in the rate saying that the compensation determined under 37 is not adequate and it is not fair.
No, he has not said it's not a question not fair. It's a question of having arrived at a certain decision, rightly or wrongly or manner, whatever, we've been uncooked or raw manner. But thing is that how that was reviewed and how that was altered, whether it has caused them substantial loss. Is loss of property, also money also amounts to loss of property, valuable property which they fear.
So that is why the Act is the Land Acquisition Act is in place, which takes care of all these kind of issues. Issue is that if you say that no, my value of the market land was wrongly estimated in the final award, you have a remedy.
That is fine. But that's not his case. That's not a case of that. That it's the wrong assessment has been done. He is questioning the whole process as to how the rate has been altered. That's all.
Rate can be altered before final award by the authorities. There is no.
Let's see some authorities on that. That's the only thing. If we can substantiate that.
Because the rate is based on the market rate of the land. Now his case should be that market land is not correctly assessed, because each petitioner will have different take, saying that my land was the land adjacent to my land was having higher cost. The Lordship has seen in the litigation that he will say that my land was higher in the price and this is not the correct market land estimate given in the final award. And then he will accept the money under protest under section 677, and then thereafter he will go to the special judicial officer for revision of rate. This is the process through which it will do. Because the award of 24th February will not get wiped out merely because saying that there is a draft award and that is my final award. There will be, as per the petitioner, there will be one award. Petitioner says that May award is a final award. I say February award is the final
19-24.
Yes, 19-2. I say 19-2 because it is published under 37. Apportionment statement. Award is a draft award. It also talks about draft only. It does not say final award. If it shows final award, then I am also, because it is not a final. In correspondence, if the parties are saying it is a final, etc., it will not matter. What will matter is the order or the award passed under section 37. Notices issued in terms of 37 for collection of compensation duly collected without protest, and this section 77. Now, after that, where is the scope, in my humble submission, where is the scope for the petitioner to cross and say that no, the award of May or the final award, can you see section 77 of the Act? 77(2). Can you see section 77(2) payment? If the person entitled to compensation shall not consent to receive it, or if there be no person competent to alienate the land, or if there is any dispute as to the title to receive the compensation or as to apportionment of it, collector shall deposit the amount of compensation in the authority to which reference under section 64 would be made. Because if there is a dispute of any respect, matter will go to the collector's office, the special authority's office. And then provided that any person admitted to be interested may receive such payment under the protest as to sufficiency of amount. So Mr. Baba will say that I am by the compensation of land in the final award has been wrongly calculated. I am entitled to amount in terms of draft award, and he will file it. Now kindly see the rider also. Next rider. Provided also nothing here, provided further no person who has received the amount otherwise and then under protest shall be entitled to make an application under subsection 1 of 64. So if he has received the amount without any protest, he cannot go to the special authority for enhancement.
Yes.
an entire case Your Lordship has seen, my lord. There is no protest. He has pocketed the entire compensation amount without protest, my lord. Rather, my lord, if it is very clear from his own RDI that he knew that what is final award. If Your Lordship will see 349, page 349. And his question from his own question at page 348, my lord, for seeking information, my lord. And that too, my lord, after 6 months of getting the amount, my lord, page 348, your lordship has the authorization.
Copy of draft order sheet.
348 of the requisition, my lord. An application under RTI.
Yes.
And then your lordship kindly come to the question at 11 at 349.
What about number 6?
Now your lordship will see 6 also, copy of draft award. Now he also said draft award, he himself said so. My letter also shows draft award, his own query shows draft award, and question number 11 also, you know. Copies of final award showing the details of names of applicant landowners, nature of their land.
This was not given to him. The one annexed in the addition was not given. It was not given to you.
It was given to everything, my lord. He will say, why should I deny him? It is under 37, my lord. He has not produced it, my lord. My problem comes, my lord, because that is why in my counter affidavit I raise the objection. Please go to the, you raise the objection as per land compensation act 2013. Go to the special authority. That is why I said that writ is not maintainable when you have the clarity. Now suddenly you have the errata moments discovery that no, I can make out my case this way. That I will declare that previous award is a final award and final award as draft award. I don't know final award is final or not.
Yes.
And the question, the all RTI is not placed. If your article will see 374 also. And this 28 November RTI application is not placed before the lordship. They play hide and seek game. Unfortunately, that's a very sad aspect of matter. When you come to the writ court, please disclose all facts, argue on law. And
where's the query of 28?
It is not there on the record below.
Mr. Chanoiso, can you produce it?
Which part?
This query. See, this is a reply. 374 reply to your query is dated 28th October 2024. Now, where's the queries?
Well,
this is this application you made at 348.
Yes, well,
this is 23/9.
Well, I'll just
so thereafter, a month later, you made other queries.
Well,
I think this had come up earlier.
I'll show.
I don't know.
Yes, Lord. It was, I pointed out on the last
yes,
same things. Yes, Lord. So therefore, Lord, that the question in my humble submission is, there is an award passed under section 37.
Now, where's the answer to the queries dated 23/9/24? Where's that?
Because
which part?
See, Mr. Chariso, just kindly see page 348 of your writ application.
Yes.
Now, these are an application, okay, under RTI Act. This queries are dated 23/9/24.
Well, 348. Lordship, looking at 348.
Page 348.
348.
Your petition.
Yes, it's the RTI application.
This is dated 23/9/2024. Where's the answers to this?
Answer to this, my lord.
Where are the answers given by them to this?
Okay.
They have the all records. They have not placed it. That's a fact.
Where are the answers to this? And the other thing, the ones you have annexed, that 374, is answers to a query dated 28th October. It's not to this query that you annexed here. So you had submitted earlier that this is the answer to your RTI application, but we would like to see your questions.
Yes.
And also the answers given to 23 and 24.
I'll clarify.
347, can you see 347?
Let him finish, I'll clarify.
Okay, we noted that.
Yes, I'll clarify.
347,
One second.
see 347 also, 347.
You seen 347, yes. One second.
And 347.
Yes, please continue.
Yes, Lord, can you see 347 also, they had the information all along about the final award.
No, fine, that you know that
There is a final, so my submission is threefold. One, that final award, they knew final award, they received the notice of final award, they received the amount under the final award, and they did not lodge any protest, which has, therefore, this is a final award. And once final award amount is accepted, my lord, they can't go back and say that draft award has become final. And then they say that the final award will, the earlier award will lapse because there has to be extension of 1 year.
this is in reply to 1st July 24.
Yes, sir, 1st July 24. Because
And where's the query to this 1st July 24? Where's the query? In the next year? This is yes. 1st July is there, the next year 20. Okay. Here, let's see it. Let's see the queries.
Yes, sir.
Details, particulars.
Yes, sir. 334,
Yes. Whether kindly provide the basis awards were computed, includes your reply. Now in the reply, what do they say? In the reply, that is query number H. Query number H, they say the award company was calculated based. That's neither yes. And then J. Whether the government allocated a budget for acquisition, if so, kindly supply the details. So J also they've given the reply. You kindly see, Mr. Chareso. J says the project completion does not fall within the budget of state government. There's no budget allocation. So the total amount like coming to deposit office is 479.46. This is the amount that's been disbursed.
Yes.
Correct.
Yes, they have disclosed in the RTI.
Okay.
So the two applications are there.
Yeah, but the thing is that this application is not there with regard to
it is there, but if I clarify, Annexure 20.
20 is that's the first application. Fine. That query is there, the answer is there. Fine. Now only 23.924, the query is not there.
I'll
the queries are there, the answer is not annexed. And then you another one is that you've annexed only queries, you have not annexed the 28.10.24, you've annexed the answers.
But
so there's a small gap.
But I'll just clarify. Annexure 20 is the first RTI application.
No, forget about
and they have given two replies for this.
The answers are there.
Two replies they have given.
Where two replies? No, we're not concerned about that anymore.
Yes.
We're concerned about the subsequent RTI queries.
Yes. But for first RTI, two replies are given. Then I'll come to that. In the first reply, reply, they have disclosed that amount. But that is page number 347.
Yes.
This is the second RTI reply.
Oh, yes.
Reply to
7, they were, that means that submission RTI journals that after you received that page 347 reply, you were aware about the amount that has been arrived. That's a 479 crores.
But which
374.
374.
Total amount.
374 is not my application. This is a reply by the PIO.
Reply. That is why when you got the reply, you were aware about the amount.
No, but we came to know on 29 July 2024.
Exactly. That is what you are aware of amount. That's submission made. And so subsequently you made another RTI reply on 23/9/24.
Well, my lord,
that query is not there.
No,
or the query is there, but answer is not annexed.
My lord, before my lord go to the second
because you
RTI.
come to 23/9, that is at page 349.
348.
Pardon my throat. Anyway, 348. Now you see, now you've got the first reply, correct? In July. Now you've come with a second query, that is in September. Now you say at 6, copy of the draft award dated 4/5/23. That you want a copy, and copies final award at C. Amounting, because you knew from the first query answer you learned that 479 something, right?
Yes.
So at 11 you ask for the details.
Yes, we ask for detail.
Now that is why this court wants to know where's the reply that they give to this one. That's simple as that.
Well, reply to this page number 348. 348. The reply to this RTI.
Yes.
The reply to this RTI is, my lord, page number, my lord, 374. That is a reply.
374.
That is a reply. See, the query is 17 points. We raise the query. Reply was 17 points.
No, you kindly see your letter dated 28 October 24.
My lord, this is a wrong reference, my lord. See the content, my lord. What is important is the content. 17 queries are there, and 17 replies. They have referred 17 queries to 17 queries.
Let's see the query to 6. The
my lord,
to 6.
my lord, my lord. That is a 348. But the first copy of the notice is issued to the undersigned applicants, landowner. They said copy of the notice bearing such enclosed. They have given.
So apart from this, there is no other query.
No other query. And number point 2, copies of the report, objection, recommendation.
1 second. There is this the copy. Now your query number 5, copy of the order passed by the collector fixing the market value so and so as given the deal section left. Now that is copy of orders influence through. Okay. Number 6, you say copy of draft award so and so. That's where you got it.
Yes.
That means that is number 6. Then number 11.
Number 11, my question number 11 would be copies of the final award showing the details.
11 is regretted. That means you do not get the details.
They don't give.
But
now HE say that.
Now you say that this is the reply to
this application.
Okay, we know.
Therefore, the HE submission that they have given the final award to us through RTI is absolutely wrong. They just say they reply this, it is exempted.
Okay.
It is exempted.
There were no other queries. There's only 2 queries you made. One was 1st July.
Yes.
And the other you made on 23rd September.
23rd September.
Which is replied by this
5th November. 5th November.
Okay.
That is clear.
Because we're getting confused.
All documents they have received under RTI only. If you want to see, right from very beginning.
No, they will not receive the details if they say is regretted here. If this is the reply to the.
That is what my lord, because if your lordship will see the entire cases, if your lordship will see the even draft award also 4th May 2023, my lord, that also my lord will find that it is also page 76, it is RTI copy only, page 97.
Well, that's given to them, yes.
Yes, everything is given to them in RTI, my lord.
So that is query number 5 and number 6. But with regard to the details, that's appeared in the additional affidavit the first time, that means. Okay. Anyway, we're digressing, we just stick on. We'll continue. Yes. Oh yes. I think you'll have to take another date.
Okay. But that's good. 25th September will be alright.
It'll be perfect, yes. Okay. Subject to what the Advocate General says.
Yes. 25th September.
But I don't think we'll be able to.
I have to come again physically.
Oh, that'd be great, yes. Right. We'll try to conclude on that day. Yes.
25th September.
Yes, finish it. Yes.
Item 20. Item 20.
Yes, we will record that. Yes.
May also come on some other day, my lord.
20?
Item 20 of hearing.
What was the matter about, Mr.
This is regarding, my lord, remastation. Remastation.
Is an old matter?
It is several rounds of litigation, my lord.
Mr. Nopure is here. He can argue the matter for you. Not trouble you to come all the way.
Let it come on some other day, my lord.
Okay. You take the date then.
My lord, I'll take after 3 weeks. I'll do interim order to continue.
Is interim order's recovery?
Yes, interim order. Interim order. Posting, my lord. Posting.
It's regarding posting.
Remonstration come posting, my lord.
Okay.
He is sort of repatriated to parent department.
Interim orders continue. 9/20. Yes. Yes. I don't think we can take other matters after we finish this matter. Alright, we'll have to hear you also, yes. Yes.
Item number 19, Lordship, I'm praying if it can be taken up. I'm ready, Lordship, but I'm praying, Lordship.
You're supposed to bring a medical expert.
Lordship, I think.
Where's the medical expert?
He's here.
He's there, his Lordship is there.
He's here.
So, what to about the matter then?
Any day, as per
trouble the medical expert. Can you give written opinion?
On what query you want to do?
Curvature of spine.
The only aspect is that there are different findings by the different medical officers, Lordship, to that effect, Lordship. And in view of
that physical. What is that? It's not
scoliosis, Lordship. Scoliosis and dorsal spine, Lordship. So and dropping of left shoulder. So there are two aspects, and Lordship, the medical officer in the last report, which is given by the Nigrams, Lordship.
He's locally from here.
Lordship. I'm praying, Lordship, any day, Lord, convenience, convenience, Lordship.
We want a senior to be here.
No, Lordship, I'll do the hearing, Lordship. In fact, Lordship, there are judgments to the effect that if there is any discrepancies, Lordship, then my only prayer is that let a medical report be created, Lordship, and I may be again retested once, Lordship.
Where Dr. Mojika? Where's the medical officer?
He's here.
On this matter, you have the authorities to back up the submissions made with apportionment and regarding this land acquisition matter.
This is a very new act, I don't think there will be direct decisions on this point.
Yes. Please come here. You are local medical officer?
No, sir, I am from Calcutta.
What is from Calcutta you've come here? No, I mean you are posted here.
Yes.
Okay. Then we can fix narrative. Not that you've come from Calcutta especially for this case.
No, I am posted here only.
In this base hospital here?
In combined hospital.
In the
Mahopat location, we have a joint combined hospital.
So you can come back.
Yes. Then you can come back, yes. Then we'll take another date.
Lordship.
Right.
Item 16 as well, my lord, may fix it some other day, my lord. This matter also, the respondents are required to seek instruction with regard to the recruitment process.
You can go today. You have to pay a cost, Mr. Chanda, since you're seeking adjournment. Yes.
Let come after 2 weeks.
Yes. Right, class of 15. Yes.
Item 18, we were ready. It's a short matter regarding regularization.
Number?
18, Lordship, 18.
You take another day.
Very well, it may be taken after 2 weeks, Lordship.
Yes.
Published.
We'll finish up this matter after lunch. Yes.
2:15, 2:15, 2:30.
Yes. Session to pen driver. No, Marshal.
Lordship, in item number 15, Your Lordship. Lordship, today, we would like to close the argument, Your Lordship. If Your Lordship permits us, if Your Lordship permits us to file a...
Which matter?
This granary.
You not heard that matter, Mr. Kasa?
Yes, Lordship. Because
heard?
Yes, Your Lordship. Many
It has not been heard, my lord. You matter has not
It's been heard.
We have heard some
Matter has not been heard. Matter has not even followed.
We'll take it after 1 week, Mr. Kasa.
Yes, Lordship.
Have you got, you're supposed to file the...
affidavit. We have filed it, Lordship.
When did you file it?
Last occasion.
Okay. Yes. 15 after 1 week, yes, on the prayer of...
Yes, obliged.
Yes. Yes.
Yes, my lord. Now the legal issue.
Yes.
The issue before the instant retribution issue, that the award which has been passed under section 37 is sought to be nullified on the ground. Is sought to be nullified on the ground that there was award anterior to the award passed under in February of 2024. So the question and the ground basically is taken by them is this, that the earlier award is the final award and 19th February award is no award in the eyes of.
Yes.
Now your lordship has seen before lunch that the compensation has been paid to the petitioners in terms of 19th February 2024 award.
Yes.
So once compensation has been received without protest,
yes,
they cannot claim that no, I should be paid in terms of draft award, because there is no challenge to this 19th February award 2024, which is the award passed in accordance with law under section 37.
Yes.
The second issue in my humble submission is, second issue is that at the end of the day, what is the claim which is there, that I should have got the higher amount for my land which has been acquired by the state. It is in a sense, in my humble submission, it is a monetary claim. It is a claim for higher compensation. The higher, if you are aggrieved with the compensation fixed by the land acquisition officer.
So your submission, yours, anything that is transpired, if it's crystallized into a monetary claim, then you go to under section 64.
Yes,
that is
and you follow the process of the Land Acquisition Act, where you have to show that I accepted the amount without under protection. 77(2). If you did not do that, you cannot come by way of writ petition and say that now permit me to go back to section 64. Whatever legal recourse is available to the petitioner is over, or he can take in accordance with law, because that issue is not before your lordship, because that issue is the remedy in law. He has remedy, he can approach, but that is for the special, because we cannot prejudge his case, in my humble submission, that he can go to the collector now. Collector may reject it. Then if your lordship will see the section 64 of the act, what the process is section 64, and he sees section 64 now. Any person, section 64, interested who has not accepted the award may, by written application to the collector, require the matter to be that the matter be referred to the collector for the determination of the authority, as the case may be, whether the objection be to the measurement of land, the amount of compensation, the amount of compensation, the person to whom it is payable, right of rehabilitation and settlement under chapter 5 and 6 of the enforcement of apportionment of the compensation among the person interested, provided that collector shall within 30 days from the date of receipt of application make a reference to the appropriate authority. Provided further that the collector fails to make such reference within a period so prescribed, the applicant may apply to the authority as the case may be, requesting it to direct the collector to make a reference to it within a period of 30 days. The authority may not is a judge as appointed under the Act. So the remedy is available, and you also would recall that last week only when the matter came in by way of writ before your lordship in respect of this stretch of land where there is a dispute between husband and wife with regard to who is entitled to receive the compensation. The lordship was dismissed and saying that you approach the collector in respect of this stretch of land. Some of the petitioners, some of the persons whose land have been acquired have accepted the amount under 19 February 2024, or they have not questioned the 19 February 2024 question, and they are happy with the compensation received. Now in this proceeding, what is being sought that you set aside the award of 19 February in essence, and we want to go back to our own May 2023 award, which is a draft award. There is no notification, there is no apportionment, there is no requirement which has been fulfilled. Therefore, my lord, in the facts and circumstances of the case, my submission is, my lord, that interference of this honorable court and in the exercise of jurisdiction is not made out, because in view of section 23, section 37, section 77, and also on view of the fact in RTI also they are saying their final award and draft award. So that is also an admission on their part. In question itself, there is an admission. In those questions, so that is all I have to submit on the deliverability. So far as the one issue is that extension of time, that issue also, it is within extended time also. If you also would see that notice under section 19 was given on 9/11/22. 9/11/22.
Yes.
1 year got over on 8/11/23.
Yes.
And 1 year extension can be on 7/11/24.
Yes.
The question is, there is no challenge to the award of February. There is no challenge to the award of February 2024 before 19 February 2024 before your lordship. So therefore, your lordship need not go into this aspect if this aspect is required to be gone into. There has to be pleading, proper reply, and proper subsidy. So this concludes, my argument on Khasi district. Now kindly see, so far as the Rivoli district is concerned, I need to show only 2-3 pages of Rivoli district from the petition only. Now in Rivoli district, if you also will see, page 55.
475. 475. In page
55, the notice, the award payment notice to each landowner. You also will see the award notice is typographically it says 70, by mistake it is 77, but it should be 37 at the page of 55. Subject land acquisition for construction of so and so. Whereas the land has been acquired by the competing authority after following the required statutory formalities in the under the provisions of Right to Fair Compensation Act, and after getting approval from the state government on 22/1/2024, and whereas it is established that you are honor tenant and right so and so as per government as per notification dated so and so, the compensation to be released to the interested person, and you are directed to appear with all these details. And you also can see the award was final award in this case in 11th January 2024, and in terms of 11th January 2024, on notice was issued on 22nd February 2024, and payment has been admittedly received by landowners and there is no protest or of any kind, under saying that the compensation assessed by the collector is on lower side and he is entitled to higher compensation, he should have closed the special authority under section 64 or the collector for referring the matter to the authority, and authority would have determined, and this could have been done only when it is shown that the amount has been received without protest, under protest, because without protest there is no remedy, because 77(2) proviso is very clear. Your Lordship may take note of that proviso. So therefore, now in the light of that, writ is not the remedy, where my friend can come and say that he has right to seek enhanced compensation in the name of draft and final award, because at the end of the day, it is the issue whether land has been, the compensation determined by collector has been correctly determined or not. And 77(2) is, kindly see once again, very clear, 77(2) at proviso, second proviso of 77(2), which says, second proviso of section 77, subsection 2, provided further that no person who has received the amount otherwise than under protest shall be entitled to make an application under subsection 1 of 64. So then petitioner, I have gone through the entire petition.
Yes.
At no place it is stated that he has received the money under the award of 11 January 2024 under the protest. And that is why my counter affidavit, which I filed, it was on the law point only. As to the maintainability, if you also will see my counter affidavit also, because it was referred to by my learned friend, my counter affidavit. And it was on the legal issue only, not going into the factual issue.
Yes.
Paragraph 5, the paragraph 5 of my counter affidavit, I have quoted section 64, and then thereafter in paragraph 6, I have quoted section 77 and relevant provision.
Where is that? You mean which affidavit, from which page? Which
In the first matter only.
So again we go back to 474 from 475.
Because this is the legal counter affidavit, this is legal stand which is applicable in all cases.
If I'm getting good exercise.
Because a batch of cases which came, so that was the legal issue. You can also kindly have counter affidavit of mine, and in the stand is not in paragraph 5. It is submitted that present application is liable to be dismissed as the petitioner have an alternate remedy as provided in section. It is submitted section 4 of the Act within 30 days can make an application.
Paragraph 5.
Paragraph 5 and paragraph 6 reference is to section 77 and second provision.
In 564. Paragraph 5, paragraph 677. Okay.
Yes, my lord. Section 64. 6 is section 77. And I rely on in 7, my lord, I have cited the judgment of
Bindi.
Pradesh High Court. High Court, my lord, where the Lordship has the consistent view is, if the Lordship will kindly see the bold portion, one of the self-imposed restriction is the High Court generally refrain from entertaining a petition when there is adequate and efficacious party and such alternate statutory remedy. Such statutory remedy has been exhausted. Availability of such alternative or so is not a bar in the entertaining. We need not multiply the circumstances with such discretionary power mainly exercised.
What's the purpose citing this? So the n number of decisions the same point.
Yes,
no, why you refer to the Andhra Pradesh High Court judgment?
Because this was all relating to land acquisition matter particularly. That is in context of that only.
Okay.
It was placed. It is only in the context of land acquisition matter. Because the Lordship is aware that in the land acquisition matters, I cited 2 High Court judgments in paragraph 7 and 8. one of Andhra Pradesh and the other is of Karnataka.
Yes. What
And then other Supreme Court judgments are on this issue are already there in subsequent lordship may just say I'm not bothering your lordship with those judgments. But so the counter affidavit not dealt with the legal issue. Actual issue when they said that there is a draft award, final award, then we filed the
additional affidavit
showing that this is the final award, and from their own case, page 91, the lordship has seen that the compensation has been received under the new award only, and the amount is also mentioned, and the amount tallies with my final award, and RTI also there is admission to that extent. So my submission is that February of 11th February 2024 or January of 24 in case of Rigoi, and February of 2024 in case of HRCA district. These are the final awards, and therefore my humble submission, and they have received the compensation without any protest. My humble submission, no case is made out by them for interference by this honorable court to the award already passed by the authorities under the law.
Right. Yes, Dr. Mozika.
The learned education has covered all the aspects. Only two things on behalf of NHIDCL.
Yes.
Madam, we'll also seize the scheme of the Act, my lord. It starts from section 11.
Let me give you a fresh page. Yes.
Primarily, section 11 is the preliminary notification, akin to section 4, my lord, earlier.
Yes.
Section 15 is 5A, my lord, earlier, objection.
Yes.
Then section 19 is earlier section 6 declaration, my lord.
Yes.
So 11, 15, 19, then comes the stage of 23, my lord. 23, learned advocate general has pointed out, my lord. Now, my lord, what is section 23, my lord? Inquiry and land acquisition award by the collector. On the day so fixed or on any other day to which the inquiry has been adjourned, the collector shall proceed to inquire into the objection, if any, which any person interested has stated pursuant to a notice given under section 21 to the measurement made under section 20 and into the value of land. So, my lord, the collector is to hold an inquiry and then decide on apportionment as is submitted with the learned AG, my lord, and determine the compensation under section 27. Now, my lord, here onwards 24, 25, 26, 27 say, my lord, how the compensation is to be determined. So, section 23 in my humble submission is not the stage of award, my lord.
Yes.
Award comes under section 30, my lord.
Yes.
And that is why, my lord, I'll just try to correlate with this. What they're saying. At page 78 of the first writ petition, my lord. Proceedings under section 23 of the LA Act, my lord. At page 78 of the, which they are saying it is a final award, my lord.
That is page
78.
Page 71.
78.
Yes.
I'll see the heading, my lord. Proceeding under section 23 of the RCT Act 2013. So this is only a stage of proceeding, my lord. This is by no means any order passed is in award, my lord. Now, my lord, I'll take your lordship to 24 is not relevant for our purpose, my lord. This is lapsing under the old act.
But it says award statement on 23. It was only inquiry, you say?
It is only proceedings with regard to inquiry, my lord.
Yes.
Now, 25 is also not relevant, my lord. 26 is relevant now, my lord. Determination of market value by collector. How the collector is to determine the market value, and that is the notification under the Indian Stamp Act for the purpose of registration. So certain parameters have been given how the land valuation is to be determined, my lord.
Yes.
Then 27, my lord. Determination of amount of compensation. The collector, having determined the market value of the land to be acquired, shall calculate the total amount of compensation to be paid to the landowner whose land has been acquired by including all assets attached to the land.
Yes.
Then it comes, my lord, parameters to be considered by collector in determination of award, the market value, damage sustained, and so many parameters, my lord. Then comes 29, determination of value, things attached to land or building. So, my lord, under this will come trees, plantation, everything under section 29. Then comes section 30, my lord. But this is slightly important, my lord. I'll just read this one.
Solution.
My lord, the subtitle is a little incorrect, my lord. It says, my lord, the collector, having determined the total compensation to be paid, shall, to arrive at the final award, impose a solution amount equivalent to 100% of the compensation amount. Explanation: for the removal of doubt, it is hereby declared that solution amount shall be in addition to the compensation payable. This 2, my lord. The collector shall issue individual award detailing the particulars of compensation payable and the detail of payment of compensation as specified in the first schedule. I'll take a lot to the first schedule, my lord. And then 3, it says, in addition to the market value of the land provided under section 26, the collector shall in every case award an amount calculated at the rate of 12% per annum on such market value for the period commencing on and from the date of publication of the notification of the social impact assessment study under subsection 2 of 4 in respect of such land till the date of the award by the collector or the date of taking possession of the land, whichever is earlier. So, my lord, this is the stage when collector 23 is only for the purpose of
inquiry,
and that also only for land compensation, my lord. Because ultimate award will not only include land compensation, my lord, this will include many things. And that is what is covered under section 30, my lord. So what I am trying to submit to your lordship, my lord, the proceedings under section 23, which my friend is saying is a final award, my lord, it is, the submission is not within the purview of that or the scheme of that, my lord.
Yes.
Then, my lord, after section 30, award is to be prepared, my lord. Then section 31 is rehabilitation and resettlement award if there is displacement, my lord. Then 33 talks about any correction if required by collector, my lord. My lord, this stage will come after section 30, my lord. Then 36 comes, my lord. The appropriate government may at any time before the award is made by the collector under section 30, the appropriate government has the power to review, my lord. Then comes, as submitted by London AG, my lord, the stage of final award. Now, when the award becomes final, my lord, the first sentence itself, the award shall be filed in the collector's office. The award shall be filed in the collector's office, and then it becomes final.
Yes.
So, my lord, in my humble submission, before the award is filed in the office of the collector, my lord, this does not attain the character of final award. Till this stage, this is simply a work in progress, my lord.
Okay. Okay.
So that is just to augment Learned AG submission, my lord. The award will become final, what is my friend is saying, only after it's filed in the office of the collector under section 37. There is no averment, no plea that previous award was filed in the office of collector, and that's how it attained finality, my lord. But this was one aspect, my lord. The second aspect which we have pleaded on behalf of NHIDCL, my lord, that the initial project cost, the estimate given by the government for land acquisition was 682 crore rupees, my lord, for the entire stretch, Reboy and East Kassis.
How much? 100 crore?
682 crore for land compensation, my lord. My lord,
the estimate given by
the government, my lord. Because we have to do DPR, my lord. At that time, we have to take into consideration what will the cost of civil construction, what will the cost of land acquisition. Now, my lord, just give the affidavit in 155.
475?
In 155, my lord.
Is that the case?
This is there are 7 matters tagged together, my lord.
7 matters?
7 matters, my lord.
7 cases, my lord.
But they are.
These two districts, my lord, the petitions are different. Some and substance same, my lord. My lord, page 3 of my affidavit, my lord.
One second. UN.
Page 3, subparagraph D, man.
Yes.
that the total amount of compensation for land and structures sanctioned for the Shillong Western Bypass project based on the tentative estimate submitted by the state government was 682 crore rupees for both Rivo and East Kasil district. However, there was a vast increase in compensation amount, that is from 682 it became 1227, my lord. That is 717 crore for East Kasil and 509 crore for Rivo district at the time of award by the respective deputy commissioner. The award will be NHI, DCL or neither certificate. The award is used in very tentative, very casual manner. My friend is trying to catch that word. You use the word award. Award can be everything is award with it. The issue of high cost of LA compensation for Shillong Western Bypass Road project awarded by the respective deputy was raised by NHI, DCL with the state government of Meghalaya in the review meeting held on so and so. Well, we said, my lord, the amount determined by the collectors, my lord, is increasing the total cost. So only on the land acquisition component is exceeding the total cost of the project, my lord.
That's it.
So, my lord, that's what we are saying, my lord, that in today's time, my lord, when the project has such huge financial implication, my lord, to take a very pedantic or very narrow view of the matter. And otherwise also there is...
Means the meeting.
Madam, I may take your lordship to page 18, my lord. This is with regard to Meghalaya. Page 18, serial number 14, my lord. A construction of 2 4-lane with paved shoulder Shillong Western Bypass, serial number 14. Second column, LA issue. LA award declared an amount to be deposited. Director T NHIDC apprised Honorable Minister of Transport and Highway that there is a vast increase in the compensation amount at the time of publication of section so and so with regard to compensation award now declared. Honorable Minister RTS expressed concern over weightage of land acquisition cost with regard to total project cost, and state government was requested to convene a meeting under the chairmanship of Honorable Chief Minister of Meghalaya and with all the concerned state officers to look into the matter. Pursuant to this, my lord, there was a meeting, it was pointed out, my lord, under the chairmanship of Deputy Chief Minister, my lord. Then a direction was issued to both the Deputy Commissioners of Rivo and East Kasils to submit revised estimate. And all this happened before the stage of section 30 also. So all this happened when the work was still in progress. The determination of compensation was a work in progress at that point of time.
Okay. That's it.
That's fine.
Any reply, Mr. Chalisu?
Short to rejoin the if lordship allow me.
How long will it take?
Well, just 5 minutes, madam. But just the reply to the TSG saying that section 23 is only order passing inquiry is wrong. When lordship see the shall make an award, the statute says shall make an award. This is the only section where collector can pass an award. Remaining section 25 onwards to 37 is highlighting the market values, assessment, solutions to a person interests. Therefore, the collector can only pass an award under section 23. That's my short reply. Now, section 37 finality of the award. Well, that can be read along with section 23. If section 37 is read alone, collector has no power to pass an award. So all this section can be read together and final award can be passed by collector under section 23. That has been passed. Secondly, my lord, HG, assuming that, my lord, the second award statement is correct, Learned HG did not answer, government did not answer. The approver, why the government approved that? On 26 May, why you approved the award? No justification, no records. Is it very vital?
No, that's shown by the affidavit that is too high.
No, state did not, my lord. State did not. The state should review. If it's okay, we are sorry, our approval is wrong, and here is a new approval. Where is the new approval for the new award? Nothing is there. That is one. Second point, my lord, vital point is the collector passed on final award on 4th May, and they say this is only a draft one. Then where is the final award passed by the collector? It is not there. For 19 February 2024, there is award statement. Where is the final award order? It is not there. And thirdly, my lord, the learned AG said that the award order, final award copy was supplied. Their own RTA reply itself says that we regret it.
It does come in the
Therefore, my lord, how the citizen would mislead this court? They come with all.
You mean where's the final award? What do you mean where's the final award? So that was which is next to the details.
Yes.
That is the final award.
No.
That 19 February 2024.
My lord,
and the next to that is the detail of every plot. That's the final award.
They did not give that award copy.
No, that is not giving is a different thing, but then that exists. That we do not deny, right?
But that copy, they say that, my lord, it is if the 4th May is our draft only, then therefore then you give me the final award. Because your RTA reply said that it reduced to 400 crore something out of 700.
No, we can't go
so
to RTI.
Therefore,
no.
They said they did not give us a copy. They did not give a final award copy. So, another reply is, my lord, we did not challenge the award statement, the second award statement which they had produced here. My lord, my lordship may mold the relief. This was never brought to the notice of the petitioner. Had they give us, we would have challenged it in the writ petition itself. Now, in the course of the hearing, they brought this. Lordship may mold the relief and interfere with this. Otherwise, Lordship may give me liberty to challenge it.
Yes.
Therefore, my humble submission is, my lord, the entire documents authored by the collecting government, including NHITSL, admitted that there is a review. And the report of the council failed to justify which provision of law empowered the government. Lordship has put that query. There is a vital question. Whether the government has the power to review the award. They fail to show. There is no provision. I have cited the authorities earlier. Supreme Court expressly held that once collector passes an award, he cannot review it. So my case is not a case of reference under section 64. In section 64, if I may place the law points in, I never raised this, but the two learned seniors have raised it. It is my duty to place the law on this. Supreme Court held that merely issuing an award notice is not enough. When you issue an award notice, you must accompany with the award paper, so that the citizen would consciously take a decision to go for reference. But I may just place that one. But just one. Since they raised this, my lord, it is my duty to clarify. Para 9 and to 11 only. The flag on my lord. It says, the main contention canvassed by the appellants in this civil appeal is whether an effective notice of the award was provided to the appellant herein as per the mandate of section 12(2) of the Land Acquisition Act. The Land Council for the petitioners and such relies upon the judgment of such and such, wherein this court has observed as under. In the light of the above, it is to be seen whether the conclusion recorded by the reference court, which has been approved by the High Court, that the application filed by the appellant was barred by time is illegally sustainable. A careful reading of the averments contained in para 2 of the application filed by the appellant under section shows that the notice issued by the collector under section 12(2) was served upon him on such. Thereafter, his advocate obtained certified copy of the award and filed application on dated and such for making a reference to the court. This implies that the copy of the award had not been sent to the appellant along with the notice, and without that, he could not effectively make an application for seeking reference. On behalf of the state government, no evidence was produced before the reference court to show that copy of the award was sent to the appellant along with the notice. Unfortunately, while deciding issue 3, this aspect has been totally ignored by the reference court, which mechanically concluded that the application filed on such was beyond the time specified under such. The learned single judge of the High Court also committed serious error by approving the view taken by the reference court, albeit without considering the fact that notice issued by the collector under such was not accompanied by a copy of the award, which was essential for effective exercise of right vested in the appellant to seek a reference under section such and such. The learned counsel appearing on behalf of the government has not disputed the opposite proposition of law. Accordingly, we are of the opinion that the opposite observation are squarely applicable to the present case, as the notice and such was not accompanied with award. In this case, there cannot have been a valid notice of the award by letters and such under section such of the Act until the appellant receive a certified copy of the award, which he did not. So, sunset. Therefore, the reference for enhancement was accordingly not barred by limitation. So, High Court in my case also, if I do that one, both the notice, award notices, they don't disclose, they don't give us. Even RTA, they're not giving it. So, their contention that I should have gone for reference, that is also unsustainable.
Yes.
So, my case is squarely, my lord. Review has been done. There is no
reference issue is concerned, my lord. My friend has not set up a case that he did not receive the award, my lord, in the entire petition.
Well, my lord, my case is not that one.
And the judgment which has been cited, my lord, it is arising out of reference court order only.
That is true.
It is not in the writ.
We've seen that.
So therefore, if yes, that is
But only one thing, if Lordship has this additional affidavit of state, my lord.
Yes.
Page 12, page 8, my lord, at serial number 12, the main petitioner, my lord, Mr. Thapa, he received 40 crore something, my lord, and again, to Lordship kindly comes to page 20, my lord. The same person again receives 41 crore.
Yes.
So 85 from one, now I got only these two entries, my lord. There may be more, my lord. There may be more entries.
He's the kingpin who received most of the award. The other ones are getting 1,65,000, 1 lakh. Also.
So from just from two entries, he received 81 or 82 crores.
My lord, it's easy to say on the part of government that he is a bad guy. He is a bad guy. But the remaining landowners,
the lion's share.
But the remaining landowners, my lord. Remaining owners, my lord. Lastly, my lord, I'm grateful.
The same person who's husband of the lady you filed a case.
No, we're not aware, my lord.
That's Hobar Molong.
My lord, I'm grateful, my lord, has given us a...
That is Hobar Molong something. That is item number Hobar Molong is that.
Today?
Yesterday, the party which was dismissed was item 40.
Okay. Not the same person.
Well, therefore, I just conclude with Lordship permission. The rules combination I've given, I've annexed the rules of the central government.
Upon the rules, Mr. Advocate General, you have not.
No, so rules are concerned, your Lordship has seen.
So are you? That means that you're not taking shelter of the rules also.
I'm saying, rules are. I have said, if your Lordship would recall that rules are not under challenge. I said rules are not under challenge. Rules requires prior permission from the government by the collector. But I said that even assuming that if the rules are not invoked, in that case also it was estimate which was being looked into by the state government. And after entire process as submitted by the DSG, the award has come under 37. Now the question before your Lordship is challenge to the award. The compensation determined in the award. So therefore, the rules, with greatest respect to my friend, rules are not here, not rules favor the stand of the government. Rules say that the collector is required to examine, collector is required to take prior possession of this state government before passing part also. But that issue in my submission does not arise here, that estimates are getting approved by the state government by NHIDCL, the project proponent and the entire project group. And if the land compensation would have gone beyond a point, then the NHIDCL would have scrapped the project. It would not have gone properly. So these are the exercises. This is a kind of exercise carried out by various government agencies and functionaries at different levels. And what you do is that you pick at the discussions at one level and declare that decision as an award, or declare that fine noting as an award, and then you file a reputation saying that this is an award. The final award in the 37 is not an award. That is the case of the British law. So the rules I have already referred to here.
Only one
page number 7 of the rule.
I missed only one point, my lord. What the NHIDCL people told me, but their mandate is only national highways, my lord. This is not even a national highway. Only because of this request of the state government, my lord, and to facilitate construction. It is not a national highway, my lord. So if central government is spending money, my lord, if it goes beyond the project cost, my lord, that will be very
So
difficult.
that's the only consideration we've seen. It's not that the people are happy. You got to feed the greed.
That's
so, yes.
Well, in other case, for example, Guwahati construction one
If you
flyover
sell
in
these
Guwahati.
lands, you know something, Mr. Changreso, on another, see, there's so many cases coming up. In this Peninsula Road also, before these acquisitions proceedings started, according to reports, that land, beyond Peninsula are going down to, it is not even worth 25 paisa square feet. That is what is the market rate there. There's nothing, it's scarce topography, mostly limestone, and you can hardly grow any crops. It's 25 paisa to 50 paisa per square feet. Even then, very difficult to get 50 paisa. Because it's a large stretch. The moment the notifications came out, for making the new highway, people who were staying in Shillong for generations had forgotten about their homestead property they had, their grandfather had along that land. They started running there and staking claim, and there were a lot of, what do you call it, attrition within the village itself. This was told by, your that time. Anyway, you know the person also. So he said that that they were at the village headmen were at a loss what to do. All coming with their own little documents of title showing that he said this land was wasteland. No one's bothered.
But that
is the thing. So that all these things happen. So like the amount of compensation has been assessed.
In this case, the land document itself says it is a fertile land.
So we just
is an arable land.
Like this court is very, very apprehensive now. The moment the super expressway comes, we can imagine the deluge of cases, similar cases will get.
That is true. So Section 77.
Section 77 or Section 15.
Amount is transferred to the landowner.
So whatever. So we just anticipating that.
Those
so once that process is complete, then Dr. Mazkar will be very busy also.
Those could have been happened.
Put a red flag with Section 64.
We'll need 2-3 special officers as reference.
Those will happen. My
flag with Section 64.
my proposed submission is those could have been happen. Well, for example, taking one example in Guwahati.
No, that's besides the point.
Of one flyover.
What we are
government sanctioned 25,000 crores.
Of law.
And in Meghalaya, my lord, when we talk about 5 crore, 300 crore, 500 crores, it seems like a heaven is going to be fallen. See the amount of costs involved in the other construction of the highways. So here the
even for that, was that AMPT road now, which a lot of PIRs being filed all the time. That road that goes to they sanction around more than 6,000 crores. Yes. But that's a big highway also. So anyway, so there'll be more and more,
And the award so-called pass by them is less than 10%. See the lordship, see the condition.
No.
It is less
budget
than 10%.
Budget includes the construction also.
Well, that is true. But the compensation for the award, the land also less than the.
You can find those submissions if you want.
Yes.
You traverse here and there, and the studies would be easier for.
Well,
but not. I don't want lengthy argument.
Yes.
It's just
the bullet points.
Bullet points for me.
24.
Yes, Mr. Pandit.
This is for hearing, but I have not seen the other side since morning.
You secure the presence.
I do not know.
Pension as yet.
My lord?
The pension matter?
No, my lord, company's net appointment. Your lordship has already directed them to consider based on the
last order.
Yes, my lord. But then again they have refused.
I think we'll have to take another day.
All right.
List this matter after
1 week or
the absence of the council response. And this earlier matter, when will you file the bullet points?
Within a week. Next week.
Yeah, list after 1 week for filing of notes and submissions. Yes. If you're interested, you're told the other side to be present. Right?
Yes.